May Your Lordship.
Yes.
Lordship, I beg to mention item number 10.
Item 10.
Yes.
Okay.
Lordship, in this matter, we have supposed to file additional affidavit. Yet we have not filed. So we need some time to file the same, Your Lordship.
Learned Counsel, MS such for the petitioner submits that the petitioner would like to file an additional
Yes.
affidavit, and therefore prays for how much time?
Uh,
2 weeks.
2 weeks.
2 weeks time for the same stop list after 2 weeks as pre.
There is an interim that may be
The
continued.
interim order passed earlier shall continue till the next date. Yes.
May I, Your Lordship? Your Lordship, I beg to mention item number 7
Hmm.
with the consent of the other parties, Your Lordship. This matter may be fixed after 2 weeks.
Learned Counsel for the appellant.
Pet-
Mr. Appellant.
Petitioner. Item number 7.
Item 7. Okay, Miss Case.
Miss case.
Okay, for the petitioner, Mr. Sun and such prays for listing the matter after 2 weeks.
2 weeks.
They submitted that the consent of the other side has been obtained and they have no objection. Stop. Accordingly, list after 2 weeks. Yes.
Your Lordship, I beg to mention another mention. That is item number 21 on behalf of K. Tama, Your Lordship. He has been appointed as an LSC. On his behalf, I am making a mention with the consent of other party that this matter may be fixed after 2 weeks. There's some personal
Let
difficulties.
it reach because actually this is listed for reference to the mediation.
Yes, Your Lordship. This is supposed to be listed on 23 of February, Your Lordship. but-
Otherwise, also, Your Lordship, this matter cannot be
Cannot
fixed
be-
for
cannot
mediation
be
because
referred.
as per the notification of this Honorable Court, Your Lordship,
Hmm.
those matters which are only compoundable can be sent to the mediation. In this matter, one of the section is non-compoundable.
Oh, I see. 21, na?
Yes.
Learned Counsel for the petitioner. You are for the
I'm for the respondent, for the victim.
For the
LSC.
respondent submits that the legal aid counsel,
Yes, Your Lordship.
But the
K. Tama.
legal aid counsel who is appearing in this matter has some difficulties today and accordingly prays for listing the matter
After 2 weeks.
after 2 weeks. Stop. Learned public prosecutor Miss MS Ginny is present and Ginny, no, and submits that
This is a notification dated 31 July.
As per notification number GHC MC-01/2025/253 dated 31st July 2025, the Guwahati High Court Mediation Center of the principal seat has
Your Lordship,
where is that?
Your Lordship will see the third page. The fourth page down below. It's an annexure A. Down below, it's action by High Court, District Court, Taluka Court. All matters having element of settlement, including matters pending under each of the following category, may be referred for mediation. Next page, Your Lordship will see in part of criminal is only criminal compoundable cases.
নিরঞ্জন কয়
So only the matters which are compoundable shall be sent for mediation.
Where is that? I cannot see.
Your
First
Lordship,
is that list given, there is such and such, then till other suitable civil cases. Then after that comes.
no, Your Lordship will see down below is action by High Court, District Court, Taluka Court. Annexure A,
Yes,
fourth page.
yes.
Your Lordship will see all matters having elements of settlement, including matters pending under each of the following categories, may be referred for mediation. These are the category. Second page. Your Lordship will see only in criminal cases, criminal compoundable case. So only criminal compoundable cases can be sent for mediation, Your Lordship.
Action by SLSA, DLSA, TLSA Mediation Center. Under this, na? You're reading from this.
No, Your Lordship.
Action by.
This is the fourth page of the
Wait. 1, 2, 3, 4. Yes.
yes. Above it's written annexure A.
There's no such thing as annexure A. Okay, yes.
Annexure A. Down below, it's serial number 2, Your Lordship. Action by High Court, District
By
Court,
High
Taluka Court.
District Court, Taluka Court, yes.
All matters having elements of settlement, including matters pending under each of the following categories, may be referred for the mediation.
Hmm.
Your Lordship will see, second page is where the criminal part is
Criminal
there.
compound, okay, okay, okay.
So only compoundable cases can be. In this case, Your Lordship,
Ah.
498A is non-compoundable.
98 is there, yes, okay. Learned, what did I say? Learned Public Prosecutor, Sir is present and submits that, okay, till 31 July 2025, I have stated, I think, no? 31st July 2025, by which the mediation center of the Guwahati High Court, principals at the principal seat has directed that only criminal compoundable cases may be referred for mediation. It is submitted that in the present case, the offense also involves section 498A IPC, which is non-compoundable, and therefore it is submitted that this case cannot be referred for mediation. Accordingly, list the matter. Otherwise, it was listed when? It was due to come up when?
23rd February.
Okay, list the matter on 23rd February.
Your Lordship, it may be fixed after 2 weeks.
Okay, then say after 2 weeks.
Hmm.
Yes.
Highly obliged.
Your Lordship,
Hmm.
I beg to mention item number 5.
Yes.
I think on behalf of Mr. Diwaja, leading counsel. Masino is out of station for domestic purpose. And I have taken consent from other party also. So matter may be listed after 3 weeks.
Heard learned counsel such and such who makes a mention on behalf of the leading counsel, Mr.
Diwaja. Domabaja.
Where is that? The name is not there in the cost list. You're mentioning item 5.
Item number 5.
Okay, Diwaja for the respondent who has some difficulties today. So it is submitted that the consent of the other side has been obtained.
My lord, I'm appearing for the petitioner.
Therefore, praise that the matter may be listed when? After?
After 3 weeks.
After 3 weeks. Stop. Learned counsel for the petitioner has no objection. List after 3 weeks is grateful. Yes.
There is an interim order
The
that may be
interim
extended.
order passed earlier shall continue till the next date.
Obliged.
Millard, I'm mentioning item number 11 on behalf of Mr. G. Lolin. He's out of station, Your Lordship.
So when do you want?
The matter may be listed after 3 weeks, Your Lordship.
Sir, learned counsel for the petitioner, Mr. Such and such, who makes a mention on behalf of the leading counsel, Mr. G. Lolin, who is out of station, and prays that the matter may be listed after 3 weeks. So praise allowed, list after 3 weeks. Yes.
There's an interim order, Your Lordship.
Order passed earlier shall continue till the next date of listing. Yes.
Pleasure.
My Lordship.
Yes.
Lordship, I beg to mention item number 25. I've
Yes.
taken the consent from opposite party, Lordship.
Mhm.
Matter may picks up the Lordship 4 weeks.
So in this case, I'm appearing for the petitioner. Let it be come up after 6 weeks, madam, not 4 weeks.
Learned counsel for the respondent, Mr. Such and such, who prays for listing the matter after 4 weeks. Stop. The learned counsel for the petitioner, Mr.
BK Singh,
BK Singh is present, and who prays that it may be listed after 6 weeks. So prayers allowed, list after 6 weeks as prayed for. Yes.
Obliged, my Lordship.
May I please, Your Honor?
Yes.
Your Honor, I beg to mention item number 17.
17. What do you want? 17.
Well, in here, my lord, service report upon respondent to is still awaited.
Learned counsel, Mr. Such and such, appearing for the petitioner, submits that the service report in respect of the respondents is still awaited, and accordingly prays for listing the matter after the return of service on the respondent. So list after 3 weeks accordingly, awaiting service report on the respondents. Yes.
Your Honor, there is an interim.
The interim, yes, the interim order passed earlier shall continue till the next date of listing. Okay.
All right.
Lordship, I beg to mention item number 26, Your Honor, on behalf of PD Nair, sir.
Hmm.
So, Your Honor is concerned from the other parties also. It's 26. Lordship,
On behalf of PD Nair,
PD Nair,
for the petitioner,
respondent.
respondent, okay. You have taken consent
Yes, Lordship.
on the learned counsel for the respondent. Mr. Such and Such makes a mention on behalf of the conducting counsel, Mr. P.D. Nair, to list the matter when?
On 24 March, sir.
On 24th March. Stop. The prayer is not objected to by the learned counsel for the petitioner, Mr. Such and Such. So accordingly, list the matter on 24th March as prayed for. Yes.
Item number 1.
Your Honor, this is anticipatory bail filed under section 482 of BNSS. My lord, before going to the fact of the case, my lord, interim was granted by the learned session court on 11/12/2025. After that, the accused person has appeared before the IO and given the statement before the IO, and bail was executed. After that, the victim.
It appeared that the accused violated the
Yes.
bail conditions.
Yes,
That's why it was.
but that was not true, my lord. I have annexed the screenshot in page number 26 to 2031. The victim himself called the accused person and her elder brother for settlement of the case. But due to not settle the case, she instantly given the statement before the JMC and state that the victim and the accused and the elder brother has given the entertaining. As per that, the bail was rejected by the learned session court. I have annexed the.
Otherwise, after the interim bail, you had appeared before
Yes.
the IO.
Yes.
Okay. Third General Counsel, Mr. Such and Such for the petitioner. Stop. This is an application under section 482 of the BNSS, praying for release of the alleged accused Sri Bengia Chabo alias Chunu. You just see from the cause title, okay? In connection with the Itanagar Women PS case number 78/25 under section 376 clause 1/354 of the IPC. Stop. It is submitted by Learned Counsel for the petitioner that the accused had been granted ad interim pre-arrest bail by the Learned Sessions Court by an order dated 11/12/2025. Stop. Thereafter, he had cooperated with the investigation and had appeared before the investigating officer, and his statement had been recorded. However, when the pre-arrest bail application was listed for hearing on 15/1/2026, the prosecution objected to the bail on the ground that the victim and her sisters had been continuously receiving phone calls from the accused and his family members, threatening them to withdraw the case. Stop. On this ground, the anticipatory bail application was rejected by the learned court below. Stop. Hence, the petitioner has approached this court, praying for pre-arrest bail on behalf of the alleged accused person. Stop. Learned PP, Ms. T. Ginny has accepted notice on behalf of the state respondent, and therefore no formal notice is called for. Please, the matter today is 23rd. When can you produce case diary?
30. On 30. 30 January.
30.
Yes.
On 31/2026, on which date the learned PP shall produce updated copy of the case diary.
Until the interim mapping.
In the interim, it is directed that till the, it is directed that in the event of arrest, the, in the interim, it is directed that in the event of arrest, the petitioner, the accused person shall be released on execution of bail bond of rupees 30,000 with one local surety to the satisfaction of the arresting authority. So, however, it is made clear that this interim order shall be subject to the final hearing on 30/1/2026. Yes.
Item number 2.
May I please, Lordship?
Acha, you just add one more line. It is also directed that the accused person shall continue to cooperate with the investigation. Okay.
May I
Yes.
please, Lordship? Lordship, this is a joint petition by the complainant and the accused for quashing of FIR dated 13/08/2024. Here, petitioner number 1 to 4 are accused and they were employed of the petition number 5,
1 to
which is
4.
a company.
1 to 4 are the accused.
Accused,
Ah,
they were employees of petition number 5. Petition number 5 is a company.
okay.
Petition number 5 is the complainant and represented by petition number 6, who is a managing director, and petition number 7 is a director of the company.
7 is the director.
Petition number 5 company has filed complaint through petition number 7, alleging that petition number 1 to 4 were billing the company a higher amount, which has caused them losses. Subsequently, an FIR was
So
lodged
the FIR was lodged by
by the company
petitioner 5 through 7.
by the company through 7.
Through 7.
May I, Lordship?
Yes.
Your Lordship, this case has been withdrawn for 2 occasions. Why? Because, my Lord, the informant has not a part of the agreement, my Lord. Here, my Lord, the interesting part is initially the information was given by the company. Later on, my Lord, the inquiry officer was there who has conducted the inquiry, and basing on his inquiry report, the FIR was registered, and he became the de facto informant in this case, my Lord. So, Your Lordship will find in page number 4, my Lord, the informant is implemented as respondent number 2.
No, respondent 2 is the investigating officer.
My Lord will kindly see the basing on which the FIR was registered, in Annexure 3, page number 26, my Lord. My Lord will see the inquiry report, my Lord. And the inquiry has been conducted, and on page number 30, my Lord. Page number 30, Your Lordship will find the receive at PS so and so. On the basis of this, the FIR was registered, and here the Deveso Chaitam was although he was the inquiry officer, but he became the de facto informant, my Lord, in this case.
Received at such and such and registered as yes. Anyway, at this stage, let's call
Lordship,
for the-
this is completely a private dispute and there is no involvement of public money. Nowhere it is reflected that any public money involved, whether in FIR or inquiry report.
We are, my Lord, not on the merit. So far as the settlement, if this IO is this person is become the part of the settlement, then we do not have any objection so far as the quashing is concerned. But now this become a piecemeal settlement, my Lord, which is not permissible, my Lord.
Let's see the settlement.
Lordship, under section under which the FIR was filed has been, all the sections are compoundable in nature.
Devi Energies, Gurazada. Devi Energies is petitioner 5. Gurazada Uday is, who is this Gurazada Uday? The one who was party in the settlement deed? Gurazada Uday Krishna. Sanjeev BG. Mangala BG, Sanjit BG, Nachi Kara.
And
Nachi Kara Sashikant.
my lord will find the annexer 7 and annexer and page number 48, annexer 7, my lord, on 2 occasions, this issue was raised, although it was not, your lord, reflected in the order. On that aspect only, the court has allowed them to withdraw this petition in 2 occasions, because the IO,
On the same ground.
yes, my lord, informant was not the party, and that objection came from the prosecution side, the same objection, my lord.
Of course, in the order, it just says prayer is allowed to withdraw.
Yes, my lord, they just taken withdrawn, they just withdraw the application.
See, your settlement deed,
Yes, Lordship.
it is executed between parties which are, see, who are not even named in the petition also. Just see your deed of settlement. MS Devi Energies is there, okay, represented by AL1, AL something, AL Nagaraju. Then who are these? Gura Zada, Uday Krishna, Sanjit BG, Mangala BG, Najikara, Sashikant, who are these?
They are all the relative of Gurazada.
No, but they are neither complainant nor are they the accused persons.
But the transaction were made on their account.
No. This will not do. Even in your petition itself, you have implemented the respondent number 2 as a respondent. See, Deveso Chaitom, who is the complainant, who has become the complainant, isn't it?
He is a IO.
See. No, maybe IO, but annexure 3, he has, on the basis of this report, the case has been registered. You just see page 30. Received that PS on such and such and registered the case. So without the knowledge of the complainant, without the complainant being made a party, how can this court entertain your petition? And the settlement deed also, nowhere, the complainant is nowhere in the settlement deed. Order dated 10/9/2025. Then order dated 15/5/2025. Withdrawn, all withdrawn with liberty to file afresh. Similar application was filed earlier.
Yes, madam, same, yes, madam.
Then
No, Lordship. IO was
same
not the
objection was raised.
IO was not made the party opposite party at that time.
If opposite party, then automatically it's not maintainable. Because it's become a piecemeal settlement, my lord.
Earlier, you had not made the
Yes.
number 2 a party.
Yes.
Now you have made him a party, but the settlement does not show his name anywhere. He's not shown anywhere. Settlement does not involve the respondent number 2. Isn't it?
Yes, Lordship. But they are all compoundable in nature. The section note which were under which the FIR has been filed.
420.
And
No, even if it's compoundable, without the complainant, how can this court entertain? Otherwise, we can issue notice to the complainant. Let's see.
yes, Lordship. Notice may be issued. An interim protection may be also
My
granted,
lord, if
Lordship.
the- my lord, if respondent is not at all the party in the settlement, my lord, then what is required
No,
from
no. The respondent number 2 may come before this court.
Yes,
and
my lord.
say that he has no
no objection? Okay, that
Ah,
can be done, my lord.
yes,
Yes, that
okay.
can be.
Heard learned counsel for the petitioner, Ms. Such and such. The present application has been filed by the by the petitioners under section 528 of the BNSS, praying for quashing of FIR lodged in the Rupa PS case number 13/2025 under section 420/406/403 and 34 of the IPC. Stop. Learned counsel for the petitioner submits that all the sections are compoundable in nature, and it is submitted that the parties have entered into a deed of settlement by which it was agreed that the party number 1 to the settlement would withdraw the complaint filed against party number 2 to 5, which resulted in the registration of FIR in crime number 0013/2024 against party number 2 and 5 of the settlement deed.
Sorry for interruption, my lord.
Yes.
One objection is, my lord, if all offences are compoundable, then this is not maintainable again, my lord. Because the for compounding the offence, the learned magistrate has a power to compound the same. Yes. The invocation of inherent power is not required at all, my lord. 528.
No, but wait. Let's see. Four 406, 402, no, 403, and 34. 34,
Sorry, my lord.
section 34.
34 is common intention, my lord.
Common intention.
Yes, my lord. That will go with the main section, my lord.
The main sections.
Yes, my lord.
You also check up once.
Yes, my lord.
420,
420 is compoundable, my lord. 420 is compoundable by a person cheated with permission of the court. And 406 is, my lord, the punishment for criminal breach of trust. That is also compoundable, my lord. And 403, my lord. 403 is, my lord, the dishonest misappropriation of property, my lord. Here, reasonable time. And
Sorry.
Compoundable.
punishment is compoundable, my lord, again.
Oh, then.
No, not maintainable.
You pray before the learned magistrate, then. Why are you approaching this court?
Under 320, the power is there, or the corresponding section under BNSS, my lord.
You file an application before the concerned magistrate or what? Magistrate, isn't
The
it?
concerned court before
Concerned
whom the
court.
case is pending, my lord.
Yes. Okay, I'm disposing it off, okay? You approach the learned court, trial court. Sir and such, what did I say? Last line. Stop. It is also the contention of the learned counsel for the petitioner that all the section that did I mention that all the sections are compoundable in nature? That I think I've already stated. Stop. It is therefore prayed that the FIR lodged in Rupa PS case number 13/2024 may be quashed and set aside in view of the settlement deed which has been arrived at between the parties. Stop. Para. The learned additional PP, Mr. T. accepts notice on behalf of the respondent number 1, the state respondent number 1, and has at the outset objected to the maintainability of the present petition. Stop. It is stated that he has submitted that the respondent number 2 / opposite party number 2 is the investigating officer as well as the complainant, in as much as an inquiry was conducted and thereafter by inquiry report, thereafter the inquiry report submitted by the respondent number 2, right report dated, there is no date, right report dated 13/8/2024, 13/8/2024, had submitted the same before the concerned PS. Stop. The inquiry report submitted by respondent number 2 was thereafter registered. The case was thereafter registered on the basis of the inquiry report submitted by the respondent number 2. Accordingly, the respondent number 2 should have also been a party in the settlement deed. However, the respondent number 2, who is the complainant, is not a party to the deed of settlement. Stop. Number 2. Another objection which the learned additional PP has raised is that since all the sections involved in the present case are compoundable in nature, i.e. section 420, 406, 403, the petitioner has the remedy of approaching the learned trial court
And section
with an
359.
application under 320 of the.
My lord, 359 now BNSS.
Okay,
Now BNSS is preparing
359. Under 359 of
corresponding to
the
320 of
BNSS
IP.
corresponding to section 320 of the CRPC. Stop. Para. The court has considered the submission of the learned counsels and has also perused the petition, the pleadings in the petition. Stop. It is also noticed that this the petitioner had approached this court earlier by filing 2 criminal petitions, being criminal petition 202/2025 and criminal petition 96/2025. Stop. Criminal petition 96 of 2025 was withdrawn on 15/5/2025 with the liberty to file afresh, and thereafter criminal petition 202 of 2025 was also withdrawn on 10/9/2025 with liberty to file afresh. Stop. Learned additional PP has submitted that both the criminal petitions were withdrawn by the petitioner as they had not made the complainant a party. They had not impleted the complainant as a party respondent in the said criminal petitions. Stop. In the present application, it is seen that the complainant / investigating officer has been impleted as respondent number 2. Stop. However, the deed of settlement does not reveal that the complainant is a party to the settlement. Stop. It is also observed that the sections involved in the present petition are all compoundable in nature, and the petitioner has the alternative remedy of the petitioner can approach the trial court praying for compounding of the offences before the concerned trial court. Stop. Para. Accordingly, this application is dismissed as not maintainable. Stop and stands disposed. Yes.
Deeply obliged.
Pleasure.
Item number 3.
May I please, Lordship?
Hmm.
May I please,
Yes.
Lordship?
Hmm.
Lordship, I am a accused person, Lordship, of a trial
Hmm.
case, NDPS case number 46/2024, Lordship.
Hmm.
Lordship, the Honorable Trial Court issued a non-bailable warrant against me on dated 1/5/2025, Lordship, for my non-appearance in the hearing, Lordship, which was purely unintentional, Lordship, and it was beyond my control, Lordship. Lordship, the photocopy of the order dated 1/5/2025, it is annexed as Annexer 1 in page number, Lordship, 1 to 6. In page number 8.
Hmm.
Lordship, fact is that I am a poor person, Lordship, and I am only the male earning member in my family. That's why during the pendency of this trial case, Lordship, I went to Maharashtra looking for job, Lordship, but I have engaged an advocate on behalf of me, dear Lordship. Lordship, after a few months, I shifted to West Bengal, Lordship, for my job, and I worked there, Lordship, from 16/4/2025 to 30/11/2025, Lordship. Lordship, the working certificate I have annexed here as Annexer 2, Lordship. It is in page number 9, Lordship. Kindly go to page number 9, Lordship.
Yes.
This is my working certificate, Lordship, given by the concerned authority, Lordship.
Hmm.
Lordship, thereafter, what happened? My engaged counsel, he has appeared on behalf of me in the court and taken a step on behalf of me up to dated, Lordship, 26/3/2025, Lordship. But Lordship, thereafter, I was unable to pay his fees on the dated 1/5/2025 due to my financial hardship, Lordship. That's why my learned counsel did not appear on behalf of me on that day, and accordingly, the court passed NBWA against me, Lordship. Lordship, along with fresh notice to the bailer, Lordship. In the next day, Lordship, as per the order dated 1/5/2025, Lordship, both the two bailers, they appeared before the trial court, and prayed for some time for my production, Lordship. The bailer informed me the matter, and I came back to my home. Now I am ready to appear before the court in the next date, which is 29 January 2026, Lordship. Lordship, but thing is that NBWA passed against me. Police may search me, Lordship. That's why I have approached before this honorable court to set aside the order and allow me to appear before the trial court without arrest, Lordship. This is my prayer.
But the accused has also been negligent, isn't it? See, 1/5/25 opportunity was given, the bailers were summoned. Then
Yes,
the
Lord.
bailers must have contacted you, your bailers, but you
Yes.
didn't listen to that also. You did not pay any heed to that also. So the bailers appeared before the court and said that you are not available.
No, Lordship, the bailer prayed for some time for my production, Lordship. And after
No. See,
after 1/5,
order
this is
dated
the next date.
See, learned counsel, listen. See, order dated 3/7/25. 3/7/25. Come to order dated 3/7/25.
3/7/25,
Seen
Lordship.
yes, order dated 3/7/25. Seen petition such and such filed by the bailers. The bailers even filed the petition, submitting
Yes.
that they have tried to find out the accused person, but the accused person is found not available. Then only. the
Yes,
case
Lordship,
will
I
file.
am, Lordship, I am outside. I was outside for my job, Lordship, and I believe on my
No,
learned counsel, but my
No, but your
learned counsel not
bailers.
inform me, Lordship, regarding the
What
matter.
about the bailers? Your bailers must have also informed you. Even if you're outside, doesn't mean that you
Whenever
cannot be
my bailior,
contacted on
Lordship,
the phone.
whenever my bailior informed me, then I came, Lordship.
No, 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 no. It appears that the order
By any
reflects that you
condition,
did not
Lordship,
come.
by any condition, Lordship, set aside the order. I am undertake. I undertake that, Lordship,
Yes,
from
PP.
date to onwards, Lordship. I will regularly present, Lordship. Lordship, there is nobody earning member in my family, Lordship. That's why I have to go outside, Lordship, for my job.
You
And
may go outside anywhere the court is not concerned, but you have to keep in touch with your bailers and with your counsel. And even if your counsel doesn't appear, your bailers have also filed a petition saying that you are not available, that you cannot be contacted.
yes,
How is
Lordship,
that?
Lordship, Lordship. That's
Yeah.
okay, Lordship. But whenever I was in Maharashtra, Lordship, there was no phone connection, Lordship. That's why I came back to Bengal, Lordship. Lordship, and
That
thing is that I am very poor due to my financial hardship. I could not pay my fees to the learned council. This is the main reason, Lordship. That's why the learned council did not want to appear on behalf of me, Lordship.
Not only that, it appears that you are taking the process of law very lightly. Yes.
Yes, Lordship, this is marriage, this is NDPS, Lordship, very serious offense, Lordship. Moreover, Lordship, how
Is it
can,
commercial quantity?
yes, Lordship, so 29, Lordship, 29 NDPS.
Lordship, it is a commercial quantity, yes,
And
Lordship.
Lordship,
But
moreover, Lordship, how can
bail has
he,
been
Lordship,
granted to
without
me.
permission of the court, he can, without permission of court, Lordship, he went outside or be state, Lordship. And Lordship,
Lordship, I
without
am an
any state.
illiterate. Lordship, I am an illiterate person, and I do not know. And even my advocate, learned counsel, not inform me the matter. I thought that my learned counsel will take necessary step, Lordship.
Lordship, that is Lordship, their personal difficulties, Lordship, that cannot be Lordship a ground to Lordship provide Lordship the to Lordship to Lordship that any kind of Lordship offense and Lordship that he could not Lordship appear before the court just because of his personal difficulties, Lordship. That Lordship in the order Lordship 3725 Lordship, it is seen that the petition already filed by the bailer Lordship, that is they tried to contact the accused person.
The bailer filed the petition. That's why I'm telling
Yes,
the
Lordship.
counsel also.
Lordship, at that time, bailiff did not contact me, Lordship. I was outside, Lordship. I could not contact, Lordship.
No,
that is not ground Lordship.
I
Yes,
could not be, Lordship,
Believable.
contacted,
That is
Lordship.
not
That's
believable.
and 29 January is my next date. I am ready to appear, Lordship, before the court. Kindly consider by any Lordship.
Then he should have he should appear there and pray for the Lordship liberty, Lordship. Yes, Lordship.
bail application, fresh bail application there, or you pray there for cancellation. Okay, before the learned
Lordship, police searching me, they may arrest me. That's why I have approached before your court, Lordship.
You appear on 29th.
Lordship, it is the first time, Lordship. Kindly consider me.
And no, this is
For
not
the
the first
interest of
time.
justice.
On several occasions, you had not been
Yes, Lordship.
appearing.
Yes, Lordship. It is recorded, Lordship. That is several. Yes,
Only two hearing, Lordship. I was not present, Lordship. On 1/5/2025, that was I was not aware about that. Thereafter, Lordship, once 3/7, I was not aware, Lordship. I was outside. That's why I have submitted my working certificate, Lordship.
Okay. Heard learned counsel for the
Lordship,
petition.
kindly consider, Lordship. Otherwise, I may be arrested and the family will be very harmed, Lordship.
This is an
And it is
application.
very
under
far distance, Lordship, from Assam, Lordship.
This is an application under Section 528 of the BNSS, praying for setting aside the NBWA order dated 1/5/2025, passed by the Learned Special Judge NTPS UPIA in NTPS case number 46/2024, arising out of DMK. What is DMK? DMK case number 67/2023. Stop. Para. This application has been filed. No, that I have already stated. No? The learned counsel for the petitioner submits that the petitioner is an accused person in the aforementioned case, information NDPS case number 46/2024. And the learned trial court had issued a non-bailable warrant of arrest against
DMK Lordship is a Doimuk police station, Lordship.
Okay. Non-bailable warrant of arrest against the petitioner due to his non-appearance on the date of hearing on 1/5/2025, which was unintentional and due to circumstances beyond his control. Stop. It is stated that the petitioner is a poor and illiterate person, and he had gone to Maharashtra to look for a job after appearing for a few dates in the trial, as he is the only earning member in his family. After a few months, he shifted to West Bengal for work, and he worked there in a shop from 16/4/2025 to 30/11/2025. And a copy of a certificate
Working
from the shop owner,
Yes,
shop
Lordship.
owner at
Proprietor.
from the proprietor has been annexed in the application. Stop. It
Yes,
is
Lordship.
further submitted that the petitioner had engaged an advocate on his behalf, and the engaged counsel had appeared before the court on previous dates. Stop. However, the petitioner failed to pay the fees of the learned counsel due to his financial hardship, and as such, the counsel did not take any steps on behalf of the petitioner, and accordingly, the trial court issued the NBWA against the petitioner, along with fresh notice to his bailers on 1/5/2025. Stop. It is further submitted that on 1/5/2025, the two bailers of the petitioner appeared before the court and prayed for some time to produce the accused person / petitioner before the court, and accordingly the prayer was allowed. Stop. Thereafter, the bailers informed the matter to the family of the petitioner, and the bailers were thereafter able to contact the petitioner with the cooperation of the family members of the petitioner. Stop. It is submitted that the next date of hearing is on 29/1/2026, and that the petitioner is ready to appear before the trial court, and therefore it is prayed that the NBWA may be recalled so that he can appear before the trial court without being arrested. Stop. It is further submitted that the petitioner had no knowledge about the issuance of the notices, nor had he received the summons, and he had no contact with his counsel or the bailers, and therefore he
Yes,
was
Lordship.
not aware about the issuance of summon against him.
Lordship.
Stop. It is therefore prayed that the NBWA dated
1/5/2025.
1/5/2025 and 3/7/2025 may be recalled, and he may be allowed to remain on the previous bail. Stop. Para. Donate additional PP, MSL Hage, appearing for the state respondent, has objected to the present application on the ground that the petitioner has been charged with offences under the NDPS Act involving commercial quantity and therefore it is a serious offense, and uh, and uh, and it is seen that the petitioner has
Violated the.
violated the bail conditions and has also been negligent in appearing before the court. Stop. It is also submitted that the learned trial court had given enough opportunities to the petitioner to appear, but the petitioner has failed to appear before the court on several occasions. Stop.
Only 2 occasions, Lordship.
The learned PP therefore submits that the present application may be dismissed as it is devoid of merit. So, para. The court has considered the submission of the learned counsels and has perused the pleadings along with the enclosures therein. Stop. As per the order of the trial court dated 1/5/2025, it is seen that the petitioner failed to appear on the fixed date, and therefore the court had issued non-bailable warrant of arrest against the petitioner with a fresh notice to his bailers, namely, Yaqub Ali and Qasim Ali.
Yes, Lordship.
Stop. Thereafter, the matter was fixed on 3/7/2025 for appearance of the accused persons and the bailers. Stop. Thereafter, subsequently, on 3/7/2025, when the matter was listed again, the petitioner failed to appear on 3/7/2025 also, and the two bailers, Yaqub Ali and Qasim Ali, filed a petition number 679/2025 stating that they have tried to find out the accused person, but the accused person is found not available. Therefore, they prayed for some time to produce the accused person before the court. Stop. Thereafter, the court issued another fresh NBWA against the present petitioner/accused, fixing 24/9/2025. What happened on 24/9? After this, there's nothing.
They have not annexed laws.
That you have not annexed 24/9/2025 order. You have not annexed.
24/9 I have not annexed, Lordship. 24/9
That means you were absent.
Yes,
You were absent on.
I was outside, Lordship. I was outside. That's why only working certificate I have annexed here.
Fixing the matter on 24/9/2025 for appearance of the accused person. Stop. The order dated 24/9/2025 has not been annexed by the petitioner herein, but it appears that the petitioner did not appear before the court even on 24/9/2025 and has instead filed the present application before this court. Stop. And this court is of the view that the petitioner has been given enough opportunities by the learned trial court to appear before the court. In fact, the bailers were also unable to get in touch with the present petitioner.
At present, it is unable. It is able, Lordship.
It is not believable that in this day and age, the petitioner would not be able to be, the petitioner could not be contacted over the phone. Stop. It is seen that, in fact, it is seen that the petitioner has been negligent and has been deliberately trying to avoid the process of law.
Lordship, by any condition, Lordship,
Especially when the offense he is involved in is a serious offense under the NDPS Act. Stop. This court finds no merit in the present application and is therefore dismissed. You appear and file a fresh bail application.
Lordship,
Yes.
much obliged, Lordship.
Item number 4.
with the liberty, Lordship, may be noted, Lordship, with the
That
liberty
liberty
to
is
file.
always there. That liberty is always there to file a subsequent application.
It should be noted, Lordship, will be better. Obliged.
Yes.
May it please your lordship. My lord, I am counsel for the petitioner in this humble joint petition under section 528 of BNSS.
Hmm.
My lord, the humble petitioners 1 to 5 are the accused persons and the de facto complainant is petitioner number 6. In
1 to 5 are the accused.
yes, my lord.
My lord, at the outset, my lord, there is no need to go to all the expect, my lord, here. My lord, the victim were not impleaded, my lord. Only the complainant and the accused person enter into an agreement. And there are 3 victims, my lord. So, my lord, may kindly come to page 23, my lord, the FIR.
23.
May I read, my lord? With most respectfully, I may take the privilege to state that during wee hour at around 2:30 a.m. on that so and so, a group of people led by 1-3 so and so holding sharp weapon that is so and so have trespassed into a staff quarter of Hotel Benjamin with a full planned strategy to kidnap and murder first victim Poru Tatup and Saurabh Borua, second number victim, and they seriously injured both of them by attacking a vital body part, and thereafter they kidnapped both the victim to the house of the alleged accused Sri so and so, and there also they attacked and cut them by local dao at vital portion of the body, likewise forehead, face, chest, etc., and taken away one scooty of bearing registration number so and so. That it is indispensable to be documented herein below that both of the victims are now admitted in Tomaruba State Hospital, Nahalagan, and highly chance to referring to Guwahati for immediate and further treatment as injured committed are deep and grievous in nature. That during the whole incident, the alleged accused person have brutally beaten and attempt to murder Poru Tatuk, victim 1, Saurabh Bora, victim 2, and Madhuja Bora, victim 3. And they all are being admitted into the aforesaid hospital in serious condition. Moreover, there is CCTV footage available at the same hotel of their chasing to catch the victim during the incident, and the same could be assessed at any time by the authority concerned. Now, agreement settlement also, 3 of them are not there.
Poru Tatup, Saurabh Borua,
And Madhuja Bora.
Bora.
And my lord may come to settlement. The settlement is in page number
42, yes.
The signatures are there in page number.
Page 42.
My lord, 42,
Yes, my
my
lord.
lord, yes. Here, accused Tamuk Abu is there, Yukar Johnson is there,
Yes.
Tamuk Paik is there, Gichik Tapuk is there, Kyoda Tang is there, and the complainant is
And
there.
the complainant, yes, my lord.
Victims are not there.
My lord, the complainant has taken full responsibility and has agreed and executed the compromise date on 10th of January 2026, my lord. My lord, the complainant and
No,
yes,
that cannot be. The injured persons, the victims themselves should enter into the compromise. This is incomplete.
Yes, my lord.
my
You,
lord,
you withdraw and you can file a fresh, it's okay. And you execute a fresh compromise deed with the injured persons.
my lord, the de facto complainant is the co-petitioner and the complainant humbly, I mean, and most respectfully
No, but
praised before this
but
honorable
when
court.
a case of this nature, grievous hurt, so it can only be with the consent of the injured persons. They themselves have to enter into the compromise.
My lord, it's been over,
Is there a problem to get in touch with them?
yes, my lord.
Why?
It's been over 8 years and we have to look for them. And the de facto complainant has,
No, if he is a relative, if
yes.
he is a relative, he can get in touch with them.
My lord, the victims were laborers of this complainant. And it's been over 8 years and looking for them would be really, hard and
So
difficult.
if they are the laborers, then how can he on their behalf enter into the compromise? Because he's not even
Because my lord,
parent or, if it was a parent of a minor, then that is also fine.
my lord, the laborers were under the care of this de facto complainant, my lord. My lord, may kindly please.
And they are adult persons. They are adult persons. How
My lord, may I please?
the complainant is not even their guardian.
My lord, at the time of the alleged incident,
Cannot be.
my lord,
That cannot be. This compromise was entered when?
on 10th of January 2026, my lord. And my lord, at the time of the alleged incident, the petitioners 1 to 5 were of very tender age and lacked maturity and understanding of the gravity of their actions, my lord. My lord, they deeply regret their immature conduct.
All that is understood, but we're just looking into the procedural aspects because unless the injured persons also enter into the compromise. In the compromise deed, it says de facto complainant and close relative.
Yes, my
Then,
lord.
if it's a close relative, then they can easily be traced out.
My lord, it's even my lord, even for the complainant, it's hard to find so and so laborers. It's been over 8 years, my lord. And my lord, may I please? May I please, my lord? May I please cite a judgment? May I please? My lord, in B.S. Joshi and others versus State of Haryana in 2003, my lord, the Honorable Division Bench led by Honorable Mr. Justice Y.K. Savarwal and Honorable Mr. Justice H.K. Seema, it was held, my lord, that the High Court has the power to cause proceedings in
Power is there, no doubt.
Yes, my lord.
Inherent power is there. But all the parties have to come before the court, isn't it? The necessary parties have to be there before the court.
My lord.
The victims are not there. The present application, are you withdrawing or will dismiss?
We are dismissing. Withdrawing, yes. Withdrawing, my lord, yes.
This
Yes.
application, the present petitioner, the learned counsel for the petitioner phrase that
My lord, may please, grant to withdraw with liberty, yes.
the learned counsel for the petitioner prays for withdrawal of the application with liberty to file a fresh stop. Accordingly, the petition is disposed of on withdrawal. The petitioner is at liberty to file a fresh if so advised. Yes.
Obliged, ma'am.
Obliged, my lord.
Item number 6.
May I please, Lordship? Lordship, we are seeking transfer of money suit number 5 of 2025 from the Court of Civil Judge, Senior Division, Changlang District, to the Court of Civil, Senior Division, Papumpara District, UP, Ayana.
Notice complete. Yes, Your
Yes.
Lordship, it has been issued already. You're appearing for?
All right, respondent number 3, Your Lordship, DC.
Respondent.
And also, Your Lordship, we are not filing our objection to their prayer, Your Lordship.
Okay. Then what about this 5 and 6?
I am appealing for the 5 and 6.
Any objection?
It's up in wisdom of your honorable court, my lord.
No, what is the ground taken by them?
Ground
Medical ground.
health
Medical ground.
Yes.
In that case, we'll allow.
My lord.
Let's see which para. Your reasons for seeking the transfer?
My lord, para 10 and
10
11.
and 11,
dated
yes.
Para page 11 of the transfer petition.
And annexure number 3 is the medical prescription.
Two.
Annexure 2 and 3.
Para 10. Para 10 and 11. Annexure?
Annexure number 2 and 3. Page number 42. The applicant is
Okay.
is a heart patient, Your Lordship.
So medical certificates are annexures 2 and 3.
It's a series of annexures, yes.
Okay, heard learned counsel for the petitioner, Miss such and such. Stop. Also heard learned government advocate, Miss such and such for the respondent number 1, 2, and 3, I think. Because one
One.
Food and civil supplies, Your Lordship, they have their own study council.
oh,
It
okay.
is not there.
So not there.
But there have no objection. Yes. There have no objection in regard to that.
That case, my lord, next week, my lord.
No, no, no.
It may
that
be
cannot be. We cannot pass order in your absence. We will dispose it, but you inform them. We'll list it next week. Okay.
My lord.
Such and such, the learned counsel, such and such appears for his
Lordship,
she's only
if I may please.
number 3, and learned counsel, your name, please.
Mr. B.K. Singh, my lord, on 6th of
If I may please.
For respondent number 5 and 6.
5 and 6.
None appears for the respondent number 1.
If I may please, Lordship,
Yes.
it may be passed over because he was present here only, but yes, court premises only.
Acha, okay, pass over for the time being.
Item number 8.
May I please, Your Lordship? Your Lordship, this is a joint criminal petition, Your Lordship, filed under section 2 of 528 of BNSS, Your Lordship, for quashing and setting aside of charge sheet number so and so, corresponding to Nijuri PS case number so and so, under section 452, 427, 395, 148, 201, and 34 of IPC, Your Lordship. Your Lordship, the petitioners, they are the first cousin, Your Lordship, and they have jointly approached together, Your Lordship. Your Lordship, the fact of the case is that, Your Lordship, on dated 20/05/2016, an FIR was lodged by the petitioner number 1, Your Lordship. So FIR is page number 32, Your Lordship.
32.
Yes. May I read the FIR, Your Lordship?
Also in such. Okay, that the complainant has injured parts. Such. Then after that.
After that, Your Lordship, yes, charge sheet was filed on 17/11/2016, Your Lordship. And then, Your Lordship, the actual fact of the case is that, Your Lordship, the petitioner, they being the first cousin, they have been in property dispute, Your Lordship, for 15 years, Your Lordship. And it has been even reflected in their amicable settlement agreement, Your Lordship. If Your Lordship may.
Where is the agreement? Page?
Yes, Your Lordship.
Page 70.
Yes, 70 to 76, Your Lordship.
So this is Tanna Yojo. Tanna Yojo, where is that? Tanna Yojo is petitioner number 1. Then Tana Tamar Tara is petitioner 3. Then Tana Tatap is petitioner 4. Takam Aku is petitioner 5. Priya Gongo is petitioner 6. Okay, so this Tana Yojo is the complainant.
Yes, she was the complainant, Your Lordship.
And the others are the accused person.
Yes, they are the accused person, Your Lordship. Your Lordship, realizing that FIR it was lodged because of instigation by a third party, Your Lordship. On the day of alleged incident, Your Lordship.
Yes, PP, can you close it?
Yes, Lordship, because they have already settled and they have closely related, Lordship. And if the fetal excess, Lordship, it is the trial is going on, it will go on, Lordship.
Right, Learned Counsel for the petitioner, Miss such and such. Stop. This is an application under Section 528 of the BNSS, praying for quashing and setting aside of the charge sheet number 22/16, corresponding to Nirjuli PS case. PS case. No. Wait. Quashing and setting aside of FIR dated 17/11/2026 and the charge sheet number 22/2016, which was registered as GR case number.
She already, stay was granted, Lordship, already.
Yes.
Stay already was granted, Lordship, in earlier occasion.
Order dated
4/2/25, Lordship.
Anyway, we'll dispose it of.
Yes.
Just maybe a question of instead of saying FIR and all that, you just say bring for quashing of the criminal proceedings in GR case number 357/2016 under section 452/395/148/201/34 of the IPC, pending before the Learned Judicial Magistrate First Class UPIA. Stop. Learned Counsel submits that after the after the filing of the charge sheet, the parties have entered into an amicable settlement settlement deed dated 1st October 2024. Stop. It is that the said settlement deed was entered into between the complainant MS Tana Yajo, TANAYAJO, Tana Yajo, and the accused persons, i.e. Shri Tana, you just see from the settlement deed, okay, page 70. Tana Takum such and such, Tana Tamar Tara, Tana Tatap, Srimati Takam Aku, and Srimati Priya Kongo. Stop. In the settlement deed, it has been agreed between the parties that during the pendency of the trial, the parties have agreed to settle the matter amicably, as the complaint was lodged because of a misunderstanding that arose due to the instigation of a third party. Stop. Now that the misunderstanding has been resolved, the complainant/first party does not want to pursue the case any further. And as such, the parties have decided to settle the case through the deed of amicable settlement. Stop. It was also agreed between the parties through the compromise deed that the first party / complainant does not wish to pursue the case any further, as it is a case between family members. Stop. Uh, it was also stated in the deed of amicable settlement that the settlement was made with a free mind and without any undue influence, coercion, or without any undue influence or coercion. Stop. Para. It is therefore prayed that the criminal proceedings in GR case number 357/2026 may be quashed and set aside. Stop. Also heard learned additional PP, Ms. El Hagi, who has fairly submitted that the matter may be disposed of as the parties, as the complainant and the accused persons have already entered into a compromise, and it would be a futile exercise to continue with the trial. Stop. In view of the facts and circumstances as stated, this will be a new para, okay? In view of the facts and circumstances as stated herein above, this court is of the view that the petition can be allowed at this stage as the petitioners, as the complainant and the accused persons have jointly filed the present application under section 528 of the BNSS on the basis of the compromise deed executed between them on 1/10/2024. Stop. Accordingly, the petition is allowed and the proceedings of GR 357 of 2016 pending before the learned judicial magistrate first class UPIA is quashed and set aside. So the registry shall send back the trial court records. Petition disposed.
Item number 6, password matter.
My lord,
Yes, yes.
extremely sorry. I was the one who was absent, my lord.
Okay, can we dispose? You have
My-
any objection to the transfer?
No, no, your lordship. This may be taken to record. I have received clear instruction from the department that there is no objection from their side, my lord.
Okay.
That my written instruction may be taken into record, my lord.
Okay. Is that item 6? So
Objection.
learned counsel such and such for the petitioners present, and then what did I say? Learned counsel Mr.
T. Jamo, my lord.
T. Jamo appears for the respondent number 1, 1, 2, 4. 1, 2, and 4.
Your lordship.
You are government advocate, no?
My lord.
Standing
One,
counsel, okay.
1, 2,
Standing counsel for respondent
4,
number
my lord. 1, 2, 4.
2, and 4 is present and has submitted a copy of the communication received from the Director of Food and Civil Supplies / respondent 2, stating that the department has no objection in accepting the transfer petition of money suit number 5 from the Court of Civil Judge Senior Division Changlang to the Court of Civil Judge Senior Division UPIA. Stop. A copy of the communication is kept on record and marked as Annexure X. Stop. Learned counsel such and such for respondent number 5 and 6 also has no objection to the prayer of the petitioner, and the learned counsel Miss such and such, learned government advocate appearing for respondent number 3 also has no objections. Stop. Para. The main ground taken by the petitioner in the present application under section 24 of the CPC is reflected in paragraph 10, 11, and 12 of the present application. Stop. Para. The petitioner, the applicant slash petitioner submits that the applicant is having eye problems for many years, and he is regularly taking treatment for the same from time to time. The doctor had ultimately advised for surgery upon both the eyes, and the same was the surgery was conducted in the month of surgery already done in the month of November 2025. So it is stated that the applicant is also a heart patient, and he had undergone a heart surgery in the year 2013, and he is constantly under medical treatment. The applicant is advised to avoid heart labor and regular traveling by the cardiologist, and therefore the applicant has to avoid a long journey, and he has to periodically go for review checkup. Para. It is further stated that where is the details about the case which is pending?
In the first paragraph. Money suit number 5 of 2025.
It is therefore stated that the money suit number 5/2025 pending before the Court of Civil Judge Senior Division, Changlang District, which is pending before the which is pending between the applicant and the respondents, before the Court of Civil Judge Senior Division, Changlang District, may be transferred to the Court of Civil Judge Senior Division, UPIA. No, division. UPIA is the district or Papumpari?
Papumpari.
Okay, so
Papumpari district.
to the Learned Civil Judge Senior Division, UPIA, Papumpari district. Stop. Para. As the petition is not objected to by the respondents, the instant transfer application is allowed, and the Learned Civil Judge Senior Division, Changlang District, is directed to send the records of, no, you just say that the money suit such and such, and therefore the money suit number 5/2025 pending before the Court of Civil Judge Senior Division, Changlang District, is hereby transferred to the Court of the Civil Judge Senior Division, Papumpari District, UPIA. Stop. The registry is directed to do the needful and take necessary steps for the same. Stop. Yes.
An appearance may be fixed in the UPIA court at
Yes,
on
yes.
6th of March.
It is further directed that the parties shall appear before the Learned Civil Judge Senior Division, Papumpari District, the UPIA Papumpari District on
6th of March, ma'am.
6th of March 2026. Yes. Petition stands disposed. Okay.
My name may be recorded. BK Singh for respondent number 5.
Yes, it is already recorded.
Obliged.
Much obliged.
Item number 9.
My Lordship, before going through this civil revision
Subject
petition,
to your Lordship's convenience, we are praying for disposal.
yes, yes,
So you want
yes.
to go for full hearing now?
yes, Lordship, because
Issue is small otherwise.
yes, issue is very simple. Here, whether the Civil Judge Senior Division we're supposed to try that case, even though there is a bar under section 14 of Arunachal Pradesh Civil Courts Act, where the pecuniary jurisdiction has been clearly stated that below 10 lakhs, it needs to be tried by the civil judge junior division. Whereas civil judge junior division is available within the compound of the civil judge senior division. So in this regard, that's the main question over here, Lordship. So if for the specificity of this case, originally the case was decided by the customary court. As the customary judges are appointed by the, as per the law, 1945 regulation under section 5. And they decided, whereas instant petitioner is the original landowner. Meanwhile, the respondent has bought the land from someone else. And later on, after the customary court sitting in open field, subsequent sitting, then they decided that this respondent, he has bought from Mr. A. A cannot sell that land since the land belongs to the petitioner. So it has been settled over there in customary court, and it's there in page number 54. 54. So this is how then means customary court usually draft their judgment.
Was the matter heard by another court earlier? Another bench?
Earlier, but it was heard, but it was released. Therefore, this
on a couple of occasions, this matter were heard, but due to paucity of time, that
it could not
be completed.
Now, for the clarity, there is a clear means one order and judgment by this honorable court only. In subsequent same issue, almost same issue, same facts and circumstances, where that has been relied over there, and it has been reported in 2025, 1 GLT 133.
So you're saying that it's a covered case?
Yes. So here actually, there was civil judge senior division need to transfer that case or endorse that case to the civil judge junior division as per the order 7 rule 10b. Whereas instead of endorsing that case or return back that case to the civil judge junior division, civil judge senior division has tried that case. And that law is there in page number 20. It's annexed over there. Page number 20. That's a new law. Arunachal Pradesh Civil Courts Act. Page number 20, section 14. May I read, Lordship?
Yes.
Jurisdiction of court civil judge junior division. The jurisdiction of a court of civil judge junior division shall extend to all original suits and proceeding of civil nature and subject to the provision of the Code of Civil Procedure 1908 or any other law for the time being in force. The pecuniary jurisdiction of the Court of Civil Judge Junior Division shall extend to all civil suits which do not exceed rupees 10 lakhs. This is the limitation of the Civil Judge Junior Division. So in total, in my case, in this case, the original suit value is 200 only. And later on, during customary court, I'm the original owner. Then the person who sold that land without my knowledge, he has been imposed fine by the customary judge by stating that you need to pay fine with interest to that instant respondent who bought that land from that Mr. A. And that need to be paid 50,000. But it has brought into an appeal before the civil judge senior division. Now here, I would like to rely that case where means it has been settled by this honorable court only, by the bench of Justice Kardak. So it's reported in GLT.
Let's see.
Even that one copy is also served over there.
Oh, which one? That's CRP 25.
Yes, CRP 25.
Oh, it's here. It's here.
Yeah. So here in this case, where means where then the petitioner has filed title suit before the civil judge senior division before the.
But during the pendency of the title suit before the civil judge senior, did you raise objection regarding the jurisdiction?
That was objected verbally, but because civil judge senior division is within the compound of the junior division is within the compound of the senior division. So it need to return to that plan to as per the order 7 rule 10 of the CPC to the civil judge junior division.
That's
And
right.
it has been settled in this case also.
Pray before the court to,
Yes.
to transfer it.
Yes, yes. But
Remanded.
yes, no, it was not remanded. So that's the issue over here. Now, in this case, if Lordship see paragraph 19, where this other counsel will be making this submission by stating that as per the section 21 of this CPC rule 1 and 2, it's barred. Where this honorable court has determined and examined, if we see, it's there in page number 13, paragraph 19.
Paragraph 19 of the judgment.
Yes.
Yes.
Yes. So here, that bench has observed that section 21, rule 1 and 2 of the Civil Procedure Code provides that no objection has to the place of suing and as to the competence of court with reference to the pecuniary limits of its jurisdiction shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity. In all cases where issues are settled at or before such settlement and unless there has been a consequent failure of justice.
That's why I'm asking.
Yes.
That objection was taken.
Yes, Lordship. Now, I would like to apprise this Lordship that in this case, as per the para 28, where this honorable court has examined all the facts and circumstances in same situation, where after examining paragraph number 28, paragraph 28 may read, Lordship. Reading of the above provision of the Arunachal Pradesh Civil Courts Act 2021 clearly reflects that the jurisdiction of Court of Civil Judge Junior Division shall extend to all original suits and proceedings of civil nature and subject to the provision of the Code of Civil Procedure Code 1908 or any other law. For the time being in force, the PIC shall extend to all civil suits which do not exceed rupees 10 lakhs. Appeals from the decree or order passed by a Court of Civil Judge Junior Division in original suits or proceeding of civil nature shall lie to the Court of Civil Judge Senior Division. Thus, in my considered opinion, since the suit is valued at rupees 5 lakhs, and in our case, it's a 50,000 only. So here 5 lakhs. And the Civil Judge Senior Division being appellate Court of Civil Judge Junior Division, the suit would lie before the Civil Judge Junior Division. In terms of the section 14 of the Arunachal Pradesh Civil Courts Act. Now, subsequent reading, relevant reading is paragraph 30. Paragraph 30. On perusal of the written statement filed the petitioner, it is seen that the petitioner have not raised an objection as to the competence of the court with reference to the pecuniary limits of its jurisdiction in clear terms. However, in view of section 14, here, however, in terms of view of section 14 and 15 clause 3, 15 clause 3 is appellate provision of AP Civil Court Act, Arunachal Pradesh Act 2021, wherein it is provided that the jurisdiction of the court of a court of civil judge junior division shall extend to all original suits and proceeding of civil nature and subject to the provision of Code of Civil Procedure 1908 or any other law for the time being in force. The pecuniary jurisdiction of the Court of Civil Judge Junior Division shall extend to all civil suits which do not exceed rupees 10 lakhs and appeals from decree or order passed by a court of civil judge junior division in original suits or proceeding of civil nature shall lie to the court of civil judge senior division. Present title suit would lie before the court of civil judge junior division. Here also same facts and circumstances. Therefore, the learned civil judge senior division 0, in my view, ought to have written the plan for filing before the court of civil judge junior division. Here in this case, it has been written by the direction of this honorable court. Then after this, paragraph number 32, where means honorable court has observed by relying this Surya Dev Rai versus Ramchandra Rai and others reported in 2003, 6 SEC 675. I would like to go through the next page, page number 19, did 7. Page number 19, 7.
Paragraph 7.
Yes, of this 32. The power to issue a writ of certiorari and supervisory jurisdiction are to be exercised sparingly and only in appropriate cases where the judicial conscience of the High Court dictates it to act lest a gross failure of justice or grave injustice should occasion. Care, caution, and circumstances need to be exercised. When any of the above said two jurisdiction is sought to be invoked during the pendency of any suit or proceeding in a subordinate court and the error, though calling for correction, is yet capable of being corrected at the conclusion of the proceeding in an appeal or revision preferred there against and entertaining a petition invoking certiorari or supervisory jurisdiction of the High Court would obstruct the smooth flow or early disposal of the suit or proceeding. Now here I post next. Here it's a main crux here. The High Court may feel inclined to intervene where the error is such as if not corrected at that very moment may become incapable of correction. Here most of the cases may happen where it's preferred bench may be preferred. If suppose someone wanted to prefer in some civil judge senior division, then they will de facto they will try if suppose this has been not corrected now. At later stage, and refusal to intervene would result in travesty of justice, or where such refusal itself would result in prolong of delays. So this is how this is after this 32. Relying on that, I would like to read the maintainability of the objection be raised by then the respondent, whether it's maintainable or not. It's there in 33, paragraph 33, where means later on this respondent counsel will be objecting. In view of the above settled proposition of the Honorable Supreme Court, and having considered the facts of the present case, this court is of the view that the present petition is maintainable, as this court is unable to concur with the submission of learned counsel for the respondent on maintainability, and accordingly submission is rejected. Now, based on that, now the main reliable para is 35, Lordship. In view of what has been discussed here and above, and in the light of the law settled by the Honorable Supreme Court, coupled with the relevant provision of law as considered here and above, I am of the considered view that it would only be appropriate for the suit to be presented before the Court of Civil Judge Junior Division concerned. The Civil Judge Senior Division ought to have returned the plan to the plaintiff, respondent number 124, for approaching the Court of Civil Judge Junior Division, as the Arunachal Pradesh Civil Courts Act 2021 has laid down the pecuniary jurisdiction of a court of Civil Judge Junior Division to a subject matter whose value is not exceeding rupees 10 lakhs. Although the Court of Civil Judge Senior Division would not be quorum non-judice, thus I am of the view that since the Civil Courts Act has laid down the pecuniary jurisdiction of a court of learned civil judge junior division to a subject matter whose value is not exceeding rupees 10 lakhs, it would be appropriate for the learned civil judge, senior division, to return the title suit number this to be instituted before the court of learned civil judge, junior division. In the result, this para 36, that's the last para, so civil revision petition, succeed the impugn order dated 26, this is hereby set aside. However, if there is no civil judge junior division, there would not be a bar for the learned civil judge senior division to proceed with the matter if the territorial jurisdiction is conferred on the civil judge senior division. So this law has been, everything has been settled in this case. Now, in my case, only thing is that civil judge senior division ought to return to that petition before the civil judge junior division. That's only, Lordship. Nothing is there. So if I submit all the facts and circumstances,
So you are not coming before this court on merit?
Yes.
On the merit of the case, but
Yes.
only on this procedural aspect?
Yes. So that's the reason this Article 2 to 7 has been invoked for the supervisory jurisdiction. As this practice, if suppose it's not stopped, later on, they will file before the civil judge senior division and
in this district, Tapo Rijo district, the court of civil judge junior is available.
Yes, Lordship. It's available within the compound and under the administration of civil judge senior division only. So that's only my submission, and I raise my rejoinder later on that the respondent counsel, whatever they submit.
Otherwise, in your written statement, was this ground taken? Was this objection taken in your written statement?
Yes.
No, my lord.
Yes, Lordship, here, if we see for merit, but no, I'm not into the merit, but if we see the judgment also.
Of course, in this cited judgment also, the objection had not been taken.
Yes.
Before the trial court.
Yes, objection was not raised. Same facts and circumstances. Here means the judgment was passed by stating that I had not filed the injunction, and by mere observation that since there is one local kacha house being constructed, but in that regard I have a FIR, because in village that's around 100 kilometers from the Dapo region, that village, and there is no, I'm not exaggerating, not proper facilities there for transportation. And all those are the villagers. So from the court till that village, that's around 102 kilometers, this land disputed area. And from here, Dapo is also around 300 kilometers. And Dapo is one of the headquarters of Upper Subansiri district. Within there is one circle called Sium, this Nacho, where the land dispute is located. So here means originally in village, what happened? They settled within amongst villager as per the customary court. There means land has been decided in my favor, and the person who sold illegally, that has been imposed fine by the village customary court by stating that you need to pay fine with principal. Instead of 200, you need to pay 50,000 to the instant respondent. So meanwhile, before that trial court, the injunction was not filed. That was one of the interesting ground that I doesn't have possession. Whereas that land was under my possession because I was cultivating. Because that can be seen through the customary court judgment only. Because in village, it's very difficult to lie in front of all the witness.
No, we will not go into that.
Yes, that's why I'm not into the merit, Lordship. I'm into this technical part only. So as I relied this 2025 GLT 135.
Yes, Learned Counsel. In fact, in this case also, in this CRP, which is relied upon, they had not taken the objection before the trial court.
No,
but the court, this court has allowed.
No, my lord, that if your lordship would come to para 6, my lord. Because I'm also aware of the facts of this case also, which has been relied, because it's a connected matters I have appeared, my lord. Now, if your lordship would come to para 6.
Para 6 of?
Of this, my lord, which my brother has relied upon. CRP, para 6 itself. Mr. K. Tama, learned counsel for the petitioner, submit that petitioners have jointly filed their written statement in the aforesaid title suit and have categorically raised objection by stating that the suit is undervalued and therefore is not maintainable and proper court fees have not been paid by the plaintiffs. However, the said contents and objection of the petitioners were overlooked by the learned civil judge senior division 0 while acknowledging the written statement. So an objection was raised, madam. Here it's not the case.
No, objection raised.
My lord.
Not regarding the jurisdiction, but
Yes, my lord. Not regarding.
Suit is undervalued.
Yes, my lord.
That's something different.
Suit is undervalued. That is an objection. That is regarding the pecuniary jurisdiction. Saying that the suit is undervalued, it cannot be filed here, man. When one raises a issue,
It is undervalued.
objection regarding the value of it is the pecuniary jurisdiction.
So the petitioners regarding.
And another interesting aspect, my lord, is that this CRP was filed immediately after the orders of this of the Learned Civil Judge Senior Division 0. Here today, the CRP, in this CRP, my lord, what has happened, the order that is being put to challenge basically is from 2023, my lord, which has been challenged in 2025, my lord. Now, in the meanwhile, what has happened, my lord? The CRP was, but here, my lord, I prepared the list of dates and the judgment that I'm.
Review notice of 2023.
My lord, what has happened, my lord? Lot has transpired in between. In between.
15/5/2023.
2023, yes, my lord. That is the order by which the matter was decided. The direction, my lord, discretion of the Learned Civil Judge had exercised her discretion and decided to try the appeal de novo, my lord. My lord knows under the AP Civil Courts Act, my lord. The Learned Civil Judge has the discretion to try and appeal de novo, my lord. That discretion was tried by the order dated 15/5/2023, my lord. And that order is at my lord, page 50, my lord, which is being put to challenge in the year 2025, my lord. And why, my lord? Because the suit has been heard, witnesses examined, the defendants and all the parties filed their written statements, everything, witnesses were examined, and subsequently judgment has been given. The suit has been entirely disposed, my lord. Now the suit has been decreed in my favor, my lord, in favor of the respondent. And after that, after more than 2 years, they come before this court saying that that initial order was bad, my lord. Now, if your lordship has, the judgment is at page 24, my lord. 15/5/2023 is the order by which the appeal was decided to be tried de novo, my lord. This is the, my lord, is there, my lord, page 24.
Page 24. Yes.
Judgment, my lord, page 24, my lord. Title suit number 7 of 2023. And if my lord would come to page 26, my lord.
Yes.
The defendant contested the suit by filing written statement, man. They filed a written statement, man. And then, and basing on this, my lord, at page 29, my lord, the issues were framed. Para 4, man. On the basis of the pleadings of the party, following issues have been framed for adjudication, man. So it's not a case where the parties were not given opportunity, man. Now my brother today, he cannot come today here and say that I mentioned it orally, man.
So long to come before the court.
Lordship.
Now the suit has been entirely disposed of.
2023, now 2025.
Yes. Now,
Then I will,
Any
I will
case, you
complete.
can
Yes,
do-
let him complete.
Now that has been done, my lord. Now if your lordship would come to page 14 of this petition, my lord. I will just take your lordship to the prayer portion.
1 minute, okay. That order to hear de novo was
This is at page 50, my lord. Date is 15/5/2023, my lord.
15/5/23. Then the impugned judgment
The impugned judgment is at page 24, my
15/11/2024.
24. My.
As per this order, Lordship,
Yes.
it's regarding the appeal only.
My lord.
This
Now,
was,
if your lordship may come to page 14, my lord. I'll take just it's a prayer portion, my lord.
Page
14, 1-4.
14. Page 14 of the petition.
Yes, petition of the petition, my lord. The prayer portion, my lord. It's a prayer, my lord. In the premises, is what said, it is graciously prayed that your lordship would be pleased to hear the parties and further be pleased to admit its petition, call for the records. Number 3, my lord. Quash and set aside the impugned judgment dated 7/2/2025 in so and so title number 7 of 23 and impugned order dated 15/5/2023 in so and so case, my lord. 2 orders are being put to change, my lord.
Which one is this 7/2/25?
7/2/2025 is the judgment, my lord, that has been delivered after the trial has been completed, my lord. Can this be done, my lord? This court, my lord, knows under the power of superintendence, my lord. My lord, the power of superintendence is exercised when the learned trial courts, my lord. They fail to exercise the jurisdiction conferred upon them, or when they don't exercise the powers conferred to them. Here is a case, my lord, 7/2/2025 is the judgment in the title suit, my lord. The title suit has completed, my lord. Evidence with parties, my lord, given opportunity, file their written statement, witnesses led by both the parties, my lord. Nowhere that statement regarding the jurisdiction was raised, my lord. And ultimately, that entire trial has culminated into this judgment dated 7/2/2025, whereby the title has been conferred upon me, my lord. My lord knows this under the CRP, this court is not sitting as a court of appeal, man. And secondly, this order dated 15/5/2023, that cannot be put to challenge after 2 years, my lord. When they decided to contest the suit, and then when the decision, the judgment and decree is in not their favor or palatable to them, they can come here and challenge that it had no jurisdiction, man. Otherwise, also what I'm saying is that if the issue is about the land, my lord, that it is wrong on the part of my brother to say that issue is only about 200. No, my lord. They raised some issues saying that it's on the merit that it was bought in 1978, 70s for an amount of rupees 200, man. We are not that on the amount now. We are on the plot of land, my lord. It's in acres, my lord. It cannot be 200 rupees for that plot of land. Man. Now, having said that, my lord, entire thing has gone by, my lord. Nothing was said, no whisper. Today, my brother is coming here before this court and saying that I made the oral submission that there is no jurisdiction. No, man. If that issue was raised, my lord, we could have addressed that issue regarding the value of the land, my lord. That has not been done, of course. because they did not raise any issue. They submitted to the it. Now, whether this court today can determine the value of the land, my lord, it cannot, my lord. This is a supervisory jurisdiction under Article 227. My lord. Now, we are not here today to decide the value of the land, whether it is 250,000, 10 lakhs or 20 lakhs, my lord. An opportunity was given to them, my lord. And that's why I was making a distinction before the, with regards to the judgment referred to by my brother. There, the objection was raised initially in the initial stage itself, saying that it is the suit is undervalued. Man. When the suit was undervalued, then and when the London Civil Judge Senior Division ignored that objection, they straight away came to court. Now here, my lord will see that the trial has completed, my lord. The suit has been decreed in my favor now. And there is a provision of appeal, my lord. This court does not sit as a court of appeal, my lord. That is my basic submission.
Yeah, appeal is always available. Appeal provision is there. And
appeal provision is there, my
Lordship, that's why.
And let me complete, then he can reply.
Yes, then.
So that is my basic argument, saying that firstly that order of 15/5/2023 cannot be challenged after 2 years when they participated in that trial. What prejudice was caused to them? They laid their evidence, man. Everything was heard. And then after the trial was completed, the judgment has been delivered in my favor. Now they cannot challenge this judgment of 7/2/2025 by way of an CRP. It has to be an appeal, man. So on those issues, man, I'll just rely on some judgment, my lord. The list of dates that I have provided, my lord, on the third page, my lord, it's the judgments that I'm relying on, my
lord. Yes, this
page,
one.
Page 3. Yes, that's just I will just read one judgment, my lord, from and just a couple of paragraphs, my lord. First, regarding the scope of supervised jurisdiction under Article 227, my lord, that I have flagged also, my lord. 1987, Volume 3, SCC 558, my lord.
You just give the para number.
Yes, para number also I have mentioned otherwise in the page 3, my lord.
Yes, 27 and 28.
Yes, my lord. This is page 27, para 27 and 28, my lord. Yes, I will read one paragraph, my lord, of this para 27.
27. Yes.
Interference by the High Courts under Article 227 of the Constitution must be within limits. This question has been considered by this court from time to time and principles laid down. This court in Ganpat Ladha versus Sasikant Vishnu Sindhu expressed this view that the High Court commits a gross error in interfering with what was a just and proper exercise of discretion by the Court of Small Causes in exercise of its power under Article 227 of the Constitution. This is unwarranted. The High Court under Article 227 has a limited jurisdiction. It was held in the case that a finding as to whether circumstances justify the exercise of jurisdiction or not, unless clearly perverse and patently unreasonable was after all a finding of fact, and it could not be interfered with either under Article 226 or 227 of the Constitution. If a proper court has come to the conclusion on the examination of the nature of the structure, the nature of duration of structure, the annexation and other 11 factors, that the structures were permanent nature, so and so, and such a finding is possible, it cannot be considered to be perverse. In such a situation, the High Court could not and should not have interfered. Just one more paragraph, ma'am. In India pipe fitting so and so, this court reiterated that the limitation of the court while exercising power under Article 227 of the Constitution is well settled. Power under Article 227 is one of judicial superintendence and cannot be exercised to upset the conclusion of facts, man. However erroneous this may be, it is possible that another court may be able to take a different view of the matter by appreciating the evidence in a different matter if it determinedly chooses to do so. This will not be justice administered according to law, to which courts are committed, notwithstanding this dissertation in session and out of session about philosophies. In that case, the court find that the High Court had arrogated to itself the powers of the appellate court. Man. That is what there is a finding of facts, man. That has been done. Man. Entire suit has been decided now, and they cannot come saying that the initial order of 2023 they cannot put to challenge, and the judgment itself by which there is a conclusion, there's a finding of facts that cannot be decided in a court of that has to be decided in a court of appeal, not under the power of superintendent. Similarly, my lord, 2022 4 SCC, my lord, paragraph 14 and 15 and 16, my lord, that I have mentioned, my lord, I will not bother your lordship. Regarding, my lord, that maintainability, my lord, what another issue is that there's an alternative remedy, my lord. There is an appeal, my lord, under the CPC, my lord. That has not been exercised, and by shortcut method, my lord, the remedy is being sought under the garb of revision, man. I will just read one judgment, my lord. 2019 9 SCC 538, man. Paragraph 11, 12, and 13, small paragraphs, my lord. Just I flagged the judgments, my lord.
Yes.
Yes, page 54. Secondly, High Court ought to have seen that when a remedy of appeal under section so-and-so read with so-and-so of the Code of Civil Procedure 1908 was directly available, respondents 1 and 2 ought to have taken recourse to the same. It is true that availability of a remedy of appeal may not always be a bar for the exercise of supervisory jurisdiction of the High Court. In so-and-so, this court held that though no hurdle can be put against the exercise of the constitutional powers of the High Court, it is a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of such remedies before he resorts to a constitutional remedy. But courts should always bear in mind a distinction between cases where such alternative remedy is available for civil courts in terms of the provisions of Code of Civil Procedure and cases where such alternative remedy is available under special enactments or statutory rules, and the fora provided therein happen to be quasi-judicial authorities and tribunals. In respect of cases falling under the first category, that is under the CPC, my lord, which may involve suits and other proceedings before civil courts, the availability of an appellate remedy in terms of provisions of CPC may have to be construed as a near total bar, man. Article 227, even a decree, otherwise there is a danger that someone may challenge in a revision under Article 227, even a decree passed in a suit on the same grounds on which respondents on 1 and 2 invoke the jurisdiction of the High Court. That is what is being done here, man. The judgment is being challenged under the garb of the supervisory jurisdiction. Appeal is being sought to be done, man. Lastly, para 13, man. Therefore, where the proceedings are under the Code of Civil Procedure and the forum is the civil court, the availability of a remedy under the CPC will deter the High Court not merely as a measure of self-imposed restriction, but as a matter of discipline and prudence from exercising its power of superintendence under the Constitution. Hence, the High Court ought not to have entertained the revision under Article 227, especially in a case where the specific remedy of appeal is provided under the CPC itself. Similar is the judgment in 2025, that I will not bother, that is at paragraphs 8 and 9, I have mentioned. 2025 SCC online SC 985.
This is also regarding maintainability.
Yes, my lord, that I have also made this under the headline, my lord.
The other one?
Now, lastly, my lord, what I am, it's regarding the objection to the jurisdiction, my lord. My lord has seen section 21, my lord, of the CPC,
Yes.
where it says that it has to be raised in the first instance. Otherwise, no court of appeal or revision will take it up, my lord, on that issue. Para 2019, volume 14, SCC 526, paragraph 57,
57.
57 and 63, I'll just read 2 paragraphs, Para 57 is at page, my lord, 555.
Yes.
The policy underlying section 21 of Code of Civil Procedure is that when the case has been tried by a court on merits and judgment rendered, my lord, here is a similar case. Tried, judgment given, has been tried by the court on merits and the judgment rendered. it should not be liable to be reversed purely on technical grounds unless it has resulted in failure of justice, my lord. The provisions akin to Section 21 are also contained in Section 11 of the Suit Valuation Act so-and-so and Section 99 of the Code of Civil Procedure. This code had the occasion to consider the principle behind Section 21 CPC and Section 11 of the Suit Valuation Act so-and-so in Kiran Singh so-and-so. In paragraph 7 of the judgment, following was laid down. The policy underlying Section 21 and 99 of the Civil Procedure Code and Section 11 of the Suits Valuation Act is the same, namely that when a case has been tried by a court on the merits and judgment rendered, it should not be liable to be reversed purely on technical grounds unless it has resulted in failure of justice. And the policy of the legislature has been to treat objections to jurisdiction, both territorial and pecuniary, as technical and not open to consideration by an appellate court unless there has been prejudice on the merits. The contention of the appellants, therefore, that the decree and judgment of the district court so-and-so should be treated as a nullity cannot be sustained under section so-and-so, so-and-so. Next, paragraph, one more paragraph, paragraph 63.
63.
What is the basic intent why this section 21 is there? 63, my lord, at page 558. Now, reverting back to the facts of this case, it is apparent from the judgment dated 22/1/2016 of the additional district judge that no objection to the competence of the additional district judge to decide the case was taken by any of the parties. No objection having been taken to the pecuniary jurisdiction of the additional district judge. Section 21 of the Civil Procedure Code comes into play. Subsection 2 of the Section 21 provides that no objection as to competence of the court with reference to pecuniary limits or the jurisdiction shall be allowed by any appellate or revisional court unless conditions mentioned therein are fulfilled. No objection has been raised by the respondent tenant regarding competence of the court. Subsection 2 precludes the revisionist to raise any objection regarding competence of the court, and further, a revisional court ought not to have allowed such objection regarding competence of the Court of Additional District Judge to decide the suit. The respondent tenant did not raise any objection regarding competence of the court and took a chance, my lord, same here, my lord, to obtain judgments in his favor on merits. He cannot be allowed to turn around and contend that the Court of Additional District Judge had no jurisdiction to try the small causes suit and the judgment is without jurisdiction and nullity. Section 21 has been enacted to thwart any such objection by unsuccessful party who did not raise any objection regarding competence of court and allowed the matter to be heard on merits. That is, my lord, what has been done. Man. Here also similarly, my lord, they did not raise the objection. Now the trial has completed, my lord. And now today they are coming here challenging the order, my lord, of 2023 and the judgment. Man. The judgment that has been relied on, my lord, that CRP by Justice Ette, my lord, that I have, as my lord has seen the paragraph 6, my lord. There the pecuniary value of the property of the suit was raised, man. The objection itself was raised. And when the learned civil judge senior division 0 did not look into that objection or did not consider their objection, they immediately came before this honorable court saying this learned civil judge senior division doesn't have the jurisdiction, man. That is a case, man. Here is a case where the trial has completed and there is a bar, man. There is a provision for appeal, man, under CPC, man. Now today we cannot decide the value of the land, man, under the revision jurisdiction, man. And as this judgment, my lord, in 2019, my lord, is seen the paragraph 63. The underlying principle is that, man, it should not be a means, my lord, where the party, my lord, decides to take a chance, my lord. Otherwise, I'm disputing the fact that the suit is undervalued or the suit is below 10 lakhs, my lord. That I am otherwise objecting to, my lord. Because that issue was never raised, so we have not made any argument or laid any evidence with regards to the value of the suit. But as per my understanding, my lord, it's the acres of land, my lord. So it is more than 10 lakhs. That is why it is before the civil judge senior division, man. Now a party cannot turn around just because the decision is not palatable or not in his favor, man. That is my basic argument, my lord, regarding the article supervised jurisdiction of the Article 227, my lord. It is very limited, my lord. And then when there is an alternative remedy, it acts as a bar, my lord. Especially, my lord, I see in the judgment, my lord, that under the CPC, my lord, when there is an alternative remedy. And Section 21, my lord, the 2019 judgment, my lord, when you have to raise it, my lord. Otherwise, you cannot now come before this court under the revision, my lord, and say that no, the suit is more than that, the value is more than that. You have to raise the value of the land, my lord. You should
In
have
the
raised
written statement, there was nothing.
nothing, my lord. I've taken your lordship to the judgment, my lord. My lord has seen.
Yes, of course, there it says.
Yes, my lord. Because that was never raised, my lord. My brother has also admitted to it. He has said that they made the oral submission, my lord.
And this 23 order, how you can challenge now?
No,
23 order. Anyway, are you done?
My lord, that is my basic. My lord.
Okay. Yes.
Here, Lordship, this order 23. Before that, may go this page number 67. Page number 67. Where originally this case has been referred from one district. Since why I'm appearing before, invoking this Article 227 reason is that my appellate court is actually Civil Judge Senior Division. If matter has been taken up before, the Civil Judge Junior Division. Now the additional district court is there in other district. So therefore from there, the matter has been referred on this 14/03/2023. Page 67. Case records put up on receipt from the Honorable Additional District and Session Court Basar, Leparada District, with order dated 02/03/2023, passed in Basar IA 1622. This is regarding the condonation of delay. And in Basar Civil Appeal 13/22. And same is re-registered as Daporizo Civil Appeal number 02/2023. In view of the above, issue notice to the parties fixing 18/4/2023 for necessary order. Now next page, 68. 68 is appellant is present with learned counsel this, respondent this. The instant appeal is transferred from the court of Honorable Additional District Judge Basar for disposal. Learned counsel for the appellant submits that he has filed an application with number 16224 for condonation of delay. Actually, this hearing was regarding the condonation of delay only. Delay of 242 days in filing the instant appeal from appeal before the additional district judge Basar. But same has not been heard yet. It has further submitted that respondent has already filed his reply against the said condonation application. In view of the above, let the matter be fixed for hearing on application number 1622 on 15/05/2023. So that's the reason why it's a consequent proceeding arising out of this condonation application before hearing the appeal memo. So now 15/05/2023, it's there in page number 50, which the learned counsel is submitting. Now that's a consequent order. So page number 50, Lordship. So as per the order of page number 50,
So by this order of 15/5/23, the appeal was admitted and the Civil Judge Senior Division ordered that it will be tried de novo.
Yes. Now
The appeal petition was deemed as a plaint.
yes.
So at this stage, if you had been aggrieved, you could have approached.
Now, Lordship, here. Now I will tell.
Like,
There is a
you were
difference.
aggrieved.
Yes, difference in between plan and memorandum of appeal. Both are different two things, Lordship.
Those
Both-
are different
yes,
things. But
yes.
what I'm trying to tell you is, you were present on this day.
Yes.
Isn't it? On 15/5/23, when it was decided that this will be treated as a plaint.
Huh.
And the Civil Judge Senior Division started to take up the matter.
Now, Lordship, here.
Yes.
As per the
And
ex
on this day
officio.
also, you did not oppose.
Yes. Now, as per the ex officio record, it's clear. It need to be as additional district and session judge Basar has transferred the administrative head Civil Judge Senior Division. and subsequently administrative judge means that in charge, civil judge senior division, or to transfer that to the civil judge junior division. Whereas here, what happened, I being a villager, as I already apprised this honorable court, my village, I'm a villager from around 100 kilometers from Dapo region. And this now appellate court, another appellate court is in different district. Now here, in this case, the council has conveyed that it's regarding the appeal only. Now here, there was a mere presumption that it's a case to determine the appeal and dispose of, and subsequently fresh titles would need to be filed, Lordship.
The applicant being a villager and all that understood.
No.
But he was represented by the council.
That's now here.
On that
Then
day.
is also a villager.
Now,
Both
now,
the parties
Yes,
are
both,
now.
so but both were represented
Lordship,
by
Lordship.
learned councils, learned councils.
Yes, Lordship, here.
So the
I'm not,
learned council
yes.
knew that this was now treated as a plaint.
no, I'm not alleging the learned council, but things that with humble submission, there was a misconception, and subsequent, if we see the order 4 regarding the plant.
No, don't say
Right.
misconception. Otherwise, you are belittling the learned council.
Yes, that's why, with humble submission. So here, after this 15, subsequent that proceeding, during that proceeding, my witness, some of the witness could not come down to that, from that village. Now, if the case has been tried before the, here I'm not alleging the concerned PO, concerned means learned council, but there is a failure of due process over here through my side, means since I could not apprise all the record, since as per the villagers record, everything, I'm the owner. But the person, Mr. B, who is my distant relative, who sold that land to Mr. C, now here, as per them, they are taking that land without my knowledge. That's the issue over here, Lordship. And meanwhile, it may be something like that might be ploy that they had contested over here. Later on, without informing me, once I came to know, now after consulting this matter.
No, but then you contested and then adduced evidence also, witnesses were examined.
No, all the witnesses has not been examined because
Were also examined.
so here, Lordship, it's akin to this same GLT that case, because there also the jurisdiction was also questioned.
No, there the jurisdiction was
Now
questioned.
here,
Yes,
Lordship, here,
that is
here, that's why here I would like to apprise this regarding the article invocation.
in their written statement, they said that they objected, saying that the suit is undervalued
Ma'am.
and not maintainable.
Yes, ma'am. And they came immediately, my lord. They did not wait for the
No, even
judgment of the suit.
even Lordship, in that the relevant paragraph, that's 22, 24, and 25, and 39. Those are the relevant para when the supervisory jurisdiction may be or can be invoked by this Honorable High Court. So,
But it depends on the timing also, the status of the case also.
Lordship, in this
Here it
case,
is a case where it is already, judgment is already passed, evidence, adduced issues, frame, everything.
but Lordship, if this practice, if this practice is continued,
No, it will not be continued because this is a very different. This
that's why I would like to rely that
This
the
can
para
be
939, Lordship, of this present this judgment.
this judgment.
Yes.
Yes.
Para 38. Here means this 4, clause 4.
I find that the only grievance you can have is that you have lost one forum, one appellate forum.
Yes, that's one of the, and now if suppose the appeal has to be preferred, then I have to travel from
The district judge.
different district. But that's not within, because there is no additional district and court over there in that district.
That cannot be held. What
No,
can
that's
we do?
why.
In
Here,
states like Nagaland and Arunachal, we have one district judge
Now,
looking
It's
after.
just 2.5
three
hours, my
districts.
lord. Itanagar, they came to Itanagar, my lord. It is just half an hour,
No,
2.5 hours, my lord.
Itanagar, that transportation is available, Lordship. There is a difference in between traveling from Dapo to Itanagar and Dapo to different district, because means of transportation, that's very limited.
Para?
Para 38 clause 4. Since those cases were also examined in previous judgment also, supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. When a subordinate court has assumed a jurisdiction which it does not have or has failed to exercise a jurisdiction which it does have, or the jurisdiction though available is being exercised by the court in a manner not permitted by law, and failure of justice or grave injustice has occasioned thereby, the High Court may step in to exercise the supervisory jurisdiction. Here in this case, Honorable Civil Judge Senior Division were well aware that Junior Division is within their compound. But how it happened, that's a question. But if this Honorable Court doesn't interfere.
Maybe, but why this objection was not raised at the first instance?
Now, in that regard, Lordship, the council were not aware, might be because council were presuming.
That you cannot say. That you cannot.
Because that has never been informed to this instant petitioner regarding those things. Because it's very new also, even the court system over here in Arunachal. So if subsequent, after this subsequent reading that the last page, that's within there, out of that 38, there's a clause 8 and clause 9. May I, Lordship? The High Court in exercise of certiorari or supervisory jurisdiction will not convert itself into a court of appeal and indulge in reappreciation or evolution of evidence or correct errors in drawing reference or correct errors of mere formula or technical character. Next is 9. In practice, the parameters for exercising jurisdiction to issue a writ of certiorari and those calling for exercise of supervisory jurisdiction are almost similar, and the writ of jurisdiction exercised by the high courts in India, unlike English courts, has almost obliterated the distinction between the two jurisdictions. While exercising jurisdiction to issue a writ of certiorari, the High Court may annul or set aside the act, order, or proceeding of the subordinate courts, but cannot substitute its own decision in place thereof. In exercise of supervisory jurisdiction, the High Court may not only give suitable direction so as to guide the subordinate court as to the manner in which it would act or proceed thereafter, or fresh, the High Court may in appropriate case itself make an order in supersession or substitution of the order of the subordinate court, as the court should have met in the facts and circumstances of the case. Now 39 is last para. Though we have tried to lay down a broad principle and working rules, the fact remaining that the parameters for exercise of jurisdiction under Article 226 or 227 of the Constitution cannot be tied down in straitjacket, formula, or rigid rules. Not less than often, the High Court would be faced with a dilemma. If it intervene in pending proceeding, there is bound to be delay in termination of proceeding. If it does not intervene, the error of moment may earn immunity from correction. The fact and circumstances of a given case may make it more appropriate for the High Court to exercise self-restraint and not to intervene, because error of jurisdiction, though committed, is yet capable of being taken care of and corrected at later stage, and wrong done. Lordship, here thing is that if this practice immune means this most, if they try before the civil judge senior division, then that practice will carry on and taking the shelter of section 21 rule 1 and 2. Since
no, it will not carry on if at the first instance the objection is.
That's why, Lordship, in to make first instant objection, because there is a misconception whether it's appeal on.
Come down. You read. At
Yes.
the end, we may sum up by saying that the power is there,
Yes.
but the exercise is discretionary, which will be governed solely by the dictates of judicial conscience, enriched by judicial experience and practical wisdom of the judge. So, depends on the fact and situation of each case. This court has to study under what circumstances the court took up the matter, whether the parties had objected at the first instance, whether there was they participated in the proceedings, and at what stage the parties are coming before this court. All this have to be seen. We cannot put it in a straight jacket and say that this rule says
Exactly.
this.
Exactly.
Just,
So
my lord,
this-
just
okay.
Lordship.
take 1 minute, my
No,
lord.
Lordship, yeah.
I'll
Here,
take,
I have relied that
You
facts and
come and appeal. You go and
Yes,
appeal.
Lordship,
You file an appeal. Okay.
Lordship, if
Yes.
this thing,
What more?
this thing is continued, then most council will prefer.
Show in the order that it is not continued.
no, my lord, there cannot be a presumption that everybody will do that, my lord.
Because Lordship,
We
thing is
will
that
differentiate.
yes,
Make
because
differentiation.
still there is no additional district and session court before the Upper Subansiri district, and I have to approach over there. But here means I'm not into the merit. In merit also I have a ground.
That's why
Yes.
this court is not going into the merit.
Yes, that's why. But
You are also not going into the
yes, but here, if it's a nascent stage of the application of AP Civil Code in Arunachal, because initial stage. Now, if this same, those practices has been carried on from 2021 and the trial has been commenced within 18 months, Lordship, very fast. This case.
Good.
So it's good.
No, Lord, it's good, but most of the witnesses
See,
could not come down.
we all have this problem, okay? Our states like Nagaland, Arunachal, we have this problem. 2-3 districts being looked after by a single judge. We all have this problem. But the parties also have to be vigilant. And the councils have to be vigilant in the sense that at the first instance, the objection has to be taken. Okay. And at the first instance, when the civil judge senior division took up the matter as a plaint, there was no objection at all. The order was passed in the presence of the learned councils. And the parties participated in the trial.
Here, Lordship,
Used evidence, everything.
here actually it's a appeal and actually appeal before the additional district court.
You
Basar.
an appeal, no?
Now they had re-endorsed to the civil judge senior division, and civil judge senior division
Look it up de novo.
Yes.
Yes.
But
Look it up de novo.
Just, my lord, just say one clarification, my lord may think that how that it came from Basar to Daporizhou, my lord. Of course, these are adjoining districts, my lord. It's now 2.5 hours at the most, my lord. What happened, my lord?
for
When
Lordship,
Kaba
personal
was,
vehicle.
that Kaba was done, my lord, against that this respondent, of course, they are all villagers, my lord. If the respondent filed an appeal, my lord, under that earlier, my lord, AFR, my lord, before the DC, my lord, but it was never taken up even after repeated, my lord, request, my lord. It was kept pending, my lord. What happened in the meantime? This AP civil courts came into force, my lord. Others I mentioned in the list of dates, my lord. Civil courts came into force, my lord. Now the DC says, I will not take up your appeal, my lord. Now what happened? Having no alternative, under the AP Civil Courts Act, my lord, appeal was filed, my lord, before the learned additional district judge, my lord. Of course, and since it was kept pending by the DC, my lord, there was some delay also, my lord. So that condonation application was also filed. The additional district judge says, no, I will not take it up. It has come back from DC. I do not have the power. So the respondent herein, my lord, filed a CRP, my lord, before this honorable court. That is 35 of 2022, my lord, where this honorable court says, district judge should take it up, my lord, and decide the issue, my lord. You have the power. Why are not you exercising it, my lord? And remanded back, my lord. Now, when it was remanded back, my lord, in the meantime, another amendment was made by which the appeal would go to the civil judge also, my lord, this senior division and junior division. So accordingly, the district judge transferred it back, my lord. That is how it happened, my lord.
Okay, any more?
It is.
That's why, Lordship, it's my humble submission that since I already exhaust that appeal of this civil judge senior division, then if suppose that order is like that, if dismissed, since
No, now appeal will lie to the district judge.
Yes.
appeal is in different district because I have to travel again, so I doesn't have personal vehicle, Lordship.
What can we say?
Since if that has been contested before civil judge junior division, then either of the party can file appeal within their in compound. So that's one thing.
But still, some party will be aggrieved. Again, it will come. So ultimately,
My lord cannot direct for setting of a court now for the petitioner.
So then
and one more thing, now otherwise that district session judge has already been sanctioned, my lord.
Mm.
That functioning is not yet started, my lord, due to lack of infrastructure. But otherwise, that already sanctioned for Upper Subansiri.
Anyway, as of now, we
Well,
will not consider that matter.
Well,
Learned counsel for the petitioner.
Lordship,
Mr.
as per the Limitation Act, Section 14,
Hmm.
may be protected me because during pendency,
Yes, yes.
that, my lord,
That we'll see.
that they will take up in the appeal, my
The
lord.
limitation.
no, that protection need to be because
My lord
it
cannot pass an order in advance, my lord.
Let's see. Hmm.
They will take it up, my lord,
Because-
and decide, my lord. The appellate court, my lord.
Because you can say before the appellate court.
Yes, ma'am.
Lordship, in
Spend litigation.
most of the time, what happened? Most of the time, in most of the appeal cases, they seek whether those liberty were not there to file appeal, and it's not the
No.
as per the order.
Any court will condone the delay which is spent in litigation. I mean,
Yes.
pursuing the matter before other forum.
But it would be
that will be always
great
followed.
that section 14.
That is not
14.
yet.
Don't worry.
Yes,
I
section
beg to
14 that
differ, my lord. That is not an issue before this court now, my lord. Today, my lord.
General Counsel
They
for
will
the
take it
petition
up, my lord, before the appellate
also
court, my
heard Mr. D. Sokina,
Right.
General Counsel for the respondent. So, matter is disposed. Jim.
lord. Obliged.
For item number 24, I have been instructed by the counsel for the petitioner to make a request for listing this matter on 29th of this month. And
Which one? Which one?
item number 24
On
and-
29th.
on 29th. And consent has already been taken from the government.
Why on 29th?
That was the instruction so far I have received for the counsel for the petitioner. We have consented together on 29th.
Okay, list the matter on 29/1/2026 on the consensus prayer of the learned counsel for the parties. Yes.
Grateful.
Item number 12.
Yeah, online question teacher was called. Whether it has been received.
This year is here.
Yes. My lord, here in this case, my lord, initially bail was granted to the accused by the learned court below.
Yes.
And later on, my lord, it was the bond was forfeited for violation of the condition.
Hmm.
And subsequently, your lordship, NBWA has been issued, and which was executed.
Hmm.
And my lord, they have perhaps filed an application before the learned court below, which is not the part of this petition, my lord. The what was the finding of the learned court below? That can be ascertained only from the record, my lord.
Oh, it was rejected.
Yes, Your Honor. This is what dismissed. As there was no any valid documents of a rehab center, Your Honor. As he was in rehab center, Your Honor. So he could not furnish the rehab center documents, Your Honor. As it has been closed, Your Honor. Moreover, Your Honor, there was a communication gap between the council also, and he have never received any summon from the court also, Your Honor, that he was unaware, so he could not come, Your Honor. And moreover, till today, he is in judicial custody for 150 days, Your Honor. So at least, Your Honor, one chance may be given, Your Honor. And the matter is still on CC stage, Your Honor. Even after his custody also, Your Honor. With any strict terms and conditions, Your Honor. Last chance may be given.
Can you just, excuse me, can you just give it to the VP once? You just find out
Yes, my lord.
and
Yeah,
flag it, okay?
Yes, my lord.
Yes, Lord, yes.
So, my lord, the bail rejection order is not the part of the record, my lord. And my lord, basically, my lord, they should.
Anyway, I think we'll allow this application because it is not commercial quantity also.
Yes, intermediate, madam.
It is 21B.
Yes, madam.
Plus, he is undergoing treatment.
Yes, madam. My lord, the strict condition to my lord cooperate with the trial, my lord. Cooperate with the trial, madam.
Learned counsel for the petitioner, Shri such and such, his name.
B.
I also
Takudia.
heard Mr. T. the learned additional public prosecutor for the state response. The present application has been filed under section 483 of the BNSS, praying for release of the accused person, Sadiqul Islam, who was taken into custody by the trial court due to non-appearance on 2 occasions in connection with NDPS case number 07/2024 under section 21B, small b, 21B NDPS Act, stop. Para. The case of the petitioner is that a charge sheet has been filed against wherein the petitioner is the accused himself, no?
No, Your Honor. The applicant is a brother.
Younger brother.
Yes, Your Honor.
A charge sheet has been filed against the alleged accused in connection with NJR PS case number 82/2024 under section 21B NTPS Act, and the matter was fixed on 12/3/2024 for appearance of the accused persons. Thereafter, the case was fixed again on 7/5/2024 and 27/6/2024 for appearance. Stop. Further, the matter was fixed for consideration of charge on 28/8/24, 24/10/24, 11/2/25, 21/3/25, 24/4/25, 27/5/25, and 26/2025 respectively. This is para 2 in the petition, okay? So, the petitioners, the counsel for the petitioner submits that the accused person had undergone 6 months de-addiction treatment at the rehabilitation center from 2/3/2025, and therefore the accused person had not been able to appear before the trial court on 21/3/25, 24/4/25, 27/5/25, and 26/2025. Stop. However, the learned trial court had issued non-bailable warrant of arrest against the accused person on 21/3/2025, and the court has forfeited the bail bond, alleging that the accused has remained absent on 2 occasions. Stop. Learned counsel for the petitioner submits that the aforementioned rehab center, namely Re-Habit, Re-Habit, HABIT, Foundation Bipuria, is it?
Yes, Your Honor.
Rehabit Foundation Bipuria, BHIPURIA, is no longer functioning, and as such, the accused person could not produce the documents from the rehab center. Stop. The counsel for the petitioner further submits that On the strength of the non-bailable warrant of arrest issued on 21/8. Where is that?
21/3/25, Your Honor.
Issued on 21/8, 2025. The trial court has taken the accused person into custody, and he was remanded to judicial custody, fixing 26/8/2025 for his appearance and hearing on the consideration of charge. Stop. Para. Learned Counsel submits that since 28/8/2025 submits that from 28/7/2025 till 5/8/2025, he was in Lakhimpur Medical College and Hospital for his son's medical treatment. And moreover, there was a communication gap between the engaged counsel and the accused person. And it is categorically submitted that no summon or information was received by the accused from the trial court or from his engaged counsel regarding the next date of appearance. Stop. It is submitted that the absence and non-appearance of the accused was not intentional, as he was admitted to the rehab center, and moreover, he had not received any information regarding the summons. So it is therefore prayed that the accused may be released on bail in connection with the NDPS case number 07/2024. Stop. It is also further submitted that the accused has been in judicial custody for about how many days now?
Till today, 150 days, Your Honor.
About 150 days, and the section under which he has been charged is section 21B of the NDPS Act, which is not commercial quantity. Stop. Further, the the accused is a permanent resident having immovable properties in at Fatehpur. At what was your village? Soakuchi village.
Yes, Your Honor.
Immovable properties at Soakuchi village, Assam, North Lakhimpur, Assam, and as such, there is no chance of him absconding if bail is granted. Stop. Learned additional PP has stated that if this court is inclined to grant the bail, stringent conditions may be imposed. Stop. Para. Upon consideration of the above facts and facts and circumstances, this court is of the view that the accused person had been undergoing treatment at the rehab center, and his non-appearance before the trial court was not intentional. So, moreover, the accused is charged with section 21B of the NDPS Act, which is intermediate quantity. So, and he has been in custody for more than 150 days.
Yes, Your Honor.
150
Yes.
days. So, accordingly, the petition is allowed. Stop. The accused person, namely Shadiqul Islam, is released on bail under the following terms and conditions. Stop. Number one, the execution of a bail bond of rupees 30,000 with one local surety of like amount to the satisfaction of the trial court. Number two, the accused shall appear before the trial court and shall not shall appear before the trial court on every fixed date and shall not be absent without showing cause. Stop. Number 3, the accused, you are a permanent resident of Assam, but you stay in Arunachal. You stay in Arunachal, or
No, Your Honor.
you don't?
I used to come from Lakhimpur.
Oh, you used to come from
Yes.
there. Okay, you just 1 and 2. Petition stands disposed.
Obliged. Obliged, ma'am.
Item number 13.
May I please you?
Hmm.
Well, in this case, I've raised certain 2-3 grounds on merit, but on computation of the length of detention, my lord, as of today is 63 days. So therefore, I'm entitled for a statutory bail. Since the punishment prescribed, my lord, the penalties goes up to 3 years, 5 years, and up to 14 years.
Date of arrest?
Arrest, my lord, 22/11/2025, page number 30, my lord. Page number 32.
Lapsed, PP.
Yes, my lord, the date of remand is 21/11 and date of arrest is 21/11 as per the
21,
record.
sorry, 21.
So as on today, my lord, the 63 days is completed. Now 64 days is running. And your lordship, I have received the case diary also, my lord. So the case is still under investigation or for want of FSL, my lord. And the offenses punishable is, my lord, highest is extend up to 14 years, my lord. Minimum is not 10 years.
14 years.
Minimum is not given, my lord. And the life and death is also not there. Where the requirement would be.
Yes, it will be 60 days only.
Yes, my lord. The highest punishment is in section, my lord,
5.
Section 5 of the Secret Act, my lord.
Section 3.
Do you have a copy?
Section 3, my lord.
I have it, my lord.
Section 3.
Section 329(3) BNS is bailable offense, and rest are 2 other sections. Section 3, subsection 1, subclause C.
316.
3 subsection 1 subclause C. Here, for 3(1)C is, my lord, he shall be punished with imprisonment for a term which may extend where the offense is committed in relation to any work of defense, arsenal, naval, military, or air force establishment or station mine, minefield factory, dockyard, camp, ship, or aircraft, or otherwise in relation to naval, military, or air force affairs of government, or in relation to any secret official court to 14 years. And in other case to 3 years.
3 years.
Extend to 14.
Extend.
Minimum is not prescribed, madam.
And in other cases?
And other is, madam, section 5(1)A.
3 years. It may extend to 3 years.
5(1)A is, my lord, willfully. This is the, my lord, the ingredient, and the punishment prescribed is in, my lord.
Next page.
Para or subclause 4, my lord. A person guilty of the offense under this section shall be punishable with imprisonment for term which may extend to 3 years, or with fine, or both. And other section is 329 subsection 3 of BNS.
BNS.
Yes, ma'am.
Bailable offense, my lord.
This is bailable.
Bailable offense.
Of course, BNS, we are not very familiar with the sections, but
Criminal trespass.
This is a trespass, my lord. Otherwise, this is extend to 3 months, my lord. Whoever commit criminal trespass shall be punished with imprisonment. But this is, my lord, bailable.
Okay then. The present application. Under section 483 of the BNSS has been filed seeking regular bail in respect of the alleged accused, Shri Nawang Namgyal, who was arrested on 21/11/2025 in connection with Taporijo Police Station case number 70/2025, registered under section 329 clause 3 of the BNS, read with section 3 clause 1 clause C, small c. You just check from the cost title /51A of the Official Secrets Act 1923. Stop. Heard learned counsel for the petitioner, Shri such and such, as well as learned additional PP, Shri T. Stop. At the outset, the petitioner submits that the learned counsel for the petitioner submits that it is now 62 days, right?
63.
63 days since the first date of remand, which was on 21/11/2025. Stop. And therefore, since the mandatory period of investigation is 60 days in the aforementioned sections, the petitioner is entitled to default bail, as the investigating agency has failed to file the charge sheet till date. Stop. It is also stated that the petition, that the accused person is a permanent resident of the state, and he is a student.
He's not a student, but he was a student, but permanent resident of Leh, Ladakh.
Oh, he's not a resident of Arunachal
No,
Pradesh.
he's from Ladakh, my lord.
Oh, sure. Then you delete that part. So you just say that it is the learned counsel for the petitioner therefore submits that in view of the operation of law, the petitioner has now acquired an indefeasible right to be released on bail at this stage. Para. Learned additional PP has not objected to the prayer, as the case diary has been received, and it has been seen that and it's revealed that the first day of remand was 21/11/2025 as far as the alleged accused is concerned. Stop. Para. In view of the facts as stated above, and in view of the fact that the charge sheet has not been filed by the investigating agency till date, the petitioner, the accused person, has acquired a right to be released on bail, and therefore this petition is allowed on the following terms and conditions. Number one, the execution of a bail bond of rupees 30,000 with one. You can arrange local surety with one local surety of like amount to the satisfaction of the trial court. Stop. Number two, the accused person shall cooperate with the investigation and shall appear before the IO as and when summoned. Number three, the accused person shall not leave the jurisdiction of the trial court without leave of the court. Stop. Number four, the accused person shall not tamper with the evidence nor try to influence the witnesses in any manner, and shall not hamper the investigation.
My lord, condition number 3 shall not leave without the jurisdiction of the trial court without the prior permission. That may be very difficult for me because I'm a resident of Ladakh.
No, you just have to file an application
Yes, madam,
before
that's
the
there.
court. Yes.
Every time. Once.
No
okay.
problem. Yes. Petition is disposed.
Grateful.
Obliged, madam.
Item number 14.
My lord, by order dated 7/1/26, an interim bail was granted, and the applicant alleged accused has complied with the directions of this honorable court and appear before the Wakka police station on 10th and 10th, and thereafter 11, 12, and 13, she was fully interrogated by the police. Her statement has been recorded, my lord. And my lord, one more thing has come out, my lord. That particular area is a insurgent affected district, my lord. The lady, the alleged accused, is a lady and she's a government employee working at NEPCO. And she has a lot of trouble. She has faced trouble even going for recording the police statement. But as the mandate of the law, my lord, she has abided by the law of risking to the life also and gone there. This is a fit case for making the bail absolute. Although there might be a material, and being a government employee, she is not a flight risk. The government employee and will not tamper with the evidence.
The status report.
Yes, my lord. Statement recorded, my lord. And she's cooperated with the investigation, my lord. Her statement is here.
Is this the report?
My lord, that was the perhaps that is the earlier one, my lord, because the perhaps FIR was.
You have the latest report.
Yes, my lord. This one.
Let's see.
The first part is the statement. The first page is the statement of the alleged accused, my lord.
Okay. Otherwise, IO has no objections.
Yeah, no objection has been given in the.
The present application under section 482 of the BNSS has been filed, praying for grant of pre-arrest bail to the applicant in connection with Wakka Police Station case number 03/25 dated 29/12/2025, registered under section, what is that?
Sections.
You have not stated in your first title.
Madam, this was also filed without a copy of the FIR.
That's
But the section is Wakka PS case number 03/25.
It's here.
Yes.
Registered under section 75/80/81 of the Juvenile Justice Act.
May it please your lordship, my lord. My lord, may kindly find, but I have not seen this one. My lord, the page number 2, CWC is also made as a correspondent here, my lord.
Oh yes, CWC.
Yes, my lord.
Why? Why CWC a party
My lord, that point of
in a
time.
bail application?
No, my lord, that point of time. See, my lord, it is like this. The fact is, it is like this. This girl was brought by a friend, elder sister to her, and she was given admission, and she was with her till 2026, 2025, and the applicant, alleged accused, has given her admission in the BKV school and on humanitarian ground. And thereafter, what had happened on fine morning of 26, she fell ill, my lord. She fell ill, and thereafter the principal of the BKV school, Yazili, Nepco colony, calls her up that you are the guardian of this girl, and she has fallen sick. Please take her to home. So in the meantime, next morning she went to in the morning without informing me. She came down to Naharlagan, and that ticket was arranged by her elder sister, and she stayed there. And on 28th, my lord, she committed suicide. I said, correct? Yes, next morning, my lord. That is the case, my lord. Then the course of action, my lord. Earlier, my lord, will remember 177, the territorial jurisdiction of the CRPC. And then thereafter, my lord, what had happened was, FIR was not lodged here. the body was taken, and the CWC Londing, they are the one who has lost the FIR in Waka, my lord. Londing. And then the Londing police says we do not have the jurisdiction since the disease is from Waka, and it was transferred to there, my lord.
So it was the CWC
Yes.
who had
So
filed
moto.
complaint.
They have
So
filed
moto complaint.
so moto complaints.
Okay. Under section, okay, 75/80/81 of the Juvenile Justice Act, read with section 143 clause 2/108 BNS.
Trafficking, my lord. That is trafficking will not attract from officerism, but I have everything.
No, just reciting.
Correct.
Yes. Stop. Heard learned counsel for the petitioner, Mr. T.T. Tara, as well as learned additional PP, Mr. T.A.T. for the state respondents. Stop. The respondent number 2 is the Child Welfare Committee, Longding District, who has filed the so moto complaint in the present case. Stop. Para. The case of the no, don't say that. On that interim order on 7/1/2026, this court had issued notice and had granted ad interim pre-arrest bail in favor of the accused person, Srimati Toko Odi, Toko Odi. Stop. And the condition, and one of the condition was that the accused applicant would appear before the investigating officer and record her statement within a period of 7 days from the date of the order. Stop. It is submitted by the petitioner that the alleged accused has complied with the direction of this court and has appeared before the investigating officer of the case, and her statement has been recorded. Stop. Learned counsel for the petitioner has also submitted that there is no allegation or report from the investigating agency that the accused person has violated any of the conditions set out by this court in the ad interim order dated 7/1/2026. It is accordingly prayed that the ad interim pre-arrest bail may be made absolute at this stage. Stop. Para. The learned additional PP has produced a copy of the status report dated 23/1/2025. Stop. Upon going through the same, it is seen that the alleged accused has appeared before the Ayok, and her statement has been recorded. Stop. The name of the accused here is
Toko Odi.
Toko Odi. Were you arrested? You were arrested?
No, ma'am.
No. So that means bail bond was not executed?
Not executed.
Oh. Okay, anyway, had appeared before the IO and her statement was recorded. Na? A copy of the statement of the alleged accused is also produced by the learned additional PP. Stop. No, but here it says after the completion of interrogation, anticipatory bail was executed.
Oh, yes, ma'am. That instruction I was not having, but they executed, ma'am.
The status report submitted by the IO dated 23/1/2025 also reveals that the alleged accused upon appearance before the investigating authority was arrested and the bail bonds were executed. Stop. The IO has not made any objections or made any allegations regarding non-cooperation by the alleged accused in the status report. Stop. Para. This court is, upon consideration of the above facts and circumstances, this court is inclined to allow this petition, and the interim order dated 7/1/2026 is hereby regularized and made absolute on the same terms and conditions, with the additional condition that the alleged accused shall continue to appear before the investigating agency as and when summoned, and shall cooperate fully with the investigation process. Stop. Then another condition is that the alleged accused shall not leave the jurisdiction of the trial court without leave of the court. Yes.
My lord, that will be very difficult. Khonsa. So, my lord, I was supposed to make a prayer, my lord. This time also when I went, I had encountered some difficulties. So I was supposed to make a prayer. Police escort may be provided to me while going to
while going there.
While going there, my lord. I faced genuine difficulty, my lord. That is, we were warned also.
So then you delete the last condition. It's okay that you pray before the trial court.
Grateful.
Petition disposed.
Item number 15.
Yes. Allowed. Yes. This is item 15.
My lord, I'm seeking adjournment for today on behalf of Mr. T. Tapu, the petitioner counsel. I have taken the respondent number to a consent also.
Okay. Heard the learned counsel for the petitioner, Mr. Such, who makes a mention on behalf of the conducting counsel, Mr. T. Topu,
Yes.
to list the matter. When do you want?
After 3 weeks. Yeah.
To list the matter after 3 weeks. And it is stated that the consent of the other side has been obtained. Other side is here.
Private respondent is there.
On the consent of the private respondent has been obtained. Learned BP has also no objections in that for the adjournment. Stop. Accordingly, list the matter after
3 weeks.
3 weeks. As prayed for.
Obligement.
Item number 16.
My lord, on the last occasion, my lord, we have producing the affidavit status report, my lord. My lord, this case has been culminated into final report, my lord. So now it's becoming infructuous, my lord.
Oh,
This is the status report, my lord.
otherwise this was.
Otherwise, it's a joint petition, my lord. Section
Joint
POXO was
petition
also
for quashing.
Yes, Your Lordship.
POXO was also there, my lord. Section 4 of the POXO Act.
One of the yeah, item 14. One for Uttar Pradesh.
ये ठीक है, दो था दो था तो ये इन्वेस्टिगेशन में दूसरा पार्टी मांगे हमको बोलो ये करता है ना
Same ये
नहीं वो स्टेटमेंट सी है
statement.
मेन एक ही स्टेटमेंट अलग पेज में जाने से मुश्किल मेरा ऊपर भी डाउट हो जाएगा
रिकॉर्ड अगर सबमिट हुआ है तो होना चाहिए फाइल के अंदर
वैसा फॉलो करना
पता नहीं कभी कभी नहीं देखता है सार लोग विधम लोग
मैंने पीछे में रखा था
ओहो
पर अगर पीछे रख दिया भी
लास्ट ऑफ
ये तो दिस फॉर
कभी कभी सब एक का चीज दूसरा रिकॉर्ड में घुस जाता है
हां
यहाँ है लिखा है वो सुबह देने वाला दिया अभी यहाँ नीचे से दूंगा
ये एक्चुअली ना मीडिएशन वाला बना जा साथ लोग ना हाँ पूछना नहीं डायरेक्ट जाओ एक चांस
कौन सा वाला
मीडिएशन लोग को
हाँ
डायरेक्ट डायरेक्शन देने जाओ
डायरेक्ट जाओ
नहीं होता है तो आओ
पूछना नहीं मेडिसिन में आगे उनको डायरेक्ट
जाने देना क्योंकि वो दोनों हाँ बोल देना मतलब क्षेत्र में नहीं है ना
हाँ हेलो बंद नहीं हुआ है क्या बंद किया था तो पता नहीं क्या
हाँ ठीक दिया